Chair, I believe we're ready.
Thank you, Mr. Derrickson. So with that hand clap, I will call the meeting to order for today. Aloha mai kako. Good morning, everyone, and thanks for joining us again today. This is July 27, 2022 Land Use Commission meeting. This is a hybrid meeting, which is being held at the Homer A. Maxey International Trade Resource Center, conference room number 401, which is open to the public and by also being held by interactive conference technology, which links video conference participants and other interested individuals of the public via Zoom. To comply with state law, members of the public can attend in person or view the meeting via the Zoom webinar platform. As chair, I will also be participating this morning by Zoom. For all meeting participants, I would like to stress to everyone the importance of speaking slowly, clearly, and directly into your microphone. Before speaking, please state your name and identify yourself for the record. Also, please be aware that all meeting participants are being recorded on the digital record of this Zoom meeting. Your continued participation is your implied consent to be part of the public record of this event. If you do not wish to be part of the public record, you should exit this meeting now. The Zoom conferencing technology allows the parties and each participating commissioner individual remote access to the meeting proceedings via their personal digital devices. Please note that due to matters entirely outside of our control, occasional disruptions to the connectivity may occur for one or more members of the meeting at any given time. If such disruption occurs, please let us know and be patient as we try to restore the audiovisual signals to effectively conduct business. For members of the public wishing to testify this morning, we are going to be taking a second round of public testimony at approximately 11 a.m. today, depending on the progress made with the training presentations. If you would like to access the meeting by telephone rather than by video contact, use *9 to virtually raise your hand and *9 to virtually lower your hand. You should also use the *6 function to mute and the *6 to unmute. Again, we'll take an additional round of public testimony on the training at approximately 11 a.m. today. I will also share with all participants that we take breaks from time to time, approximately every hour, about a 5 to 10 minute break. My name is Dan Giovanni, and I have the pleasure to serve as the LUC chair. We currently have 9 seated commissioners. Along with me are Commissioners Don Chang, Commissioner Nancy Cabral, Commissioner Kamakea Ohelo, Commissioner Lee Ohigashi, Commissioner Gary Okuda, Commissioner Atta, Commissioner Michael Yamane, Commissioner Kahele. Also is the LUC Executive Director, Daniel Orendanker, LUC Chief Planner, Scott Derrickson, LUC Staff Planner, Riley Hakoda, LUC Staff Planner, Martina Segura, and we welcome LUC Attorney General Julie Chena, who's joining us by Zoom today. Court reporting transcriptions are being done from this Zoom meeting. The second order of business of today is the continuation of commissioner training. At this time, I'd like to turn the meeting back over to Executive Director Daniel Orendanker to continue the training presentation.
Thank you, Mr. Chair. At this point, we'd like to pick up where we left off, and Mr. Derrickson will be providing us a training session on motions for order to show cause.
Very well.
Oh, Scott? Yeah, there's Mary Alice and Brian Lee. Oh, yeah.
Chair, you may want to recognize that we also have the Director of the Office of Planning and Sustainable Development, Mary Alice Evans, joining us in our audience, and Deputy Attorney General Brian Yee.
So acknowledged. Thank you for clarifying that, Mr. Derrickson, and welcome, Mary Alice, and welcome, Mr. Yee.
Okay, aloha kako. Okay, so I'm going to talk about orders to show cause. There we go. They are tied to district boundary amendments. It's a fairly rare occurrence when we enter into an order to show cause. The process is pretty complicated because the result potentially is a reversion of the original decision and order. There is a condition that we often we have in recent years made sure we put a condition in our petitions that absent substantial commencement of a project, that the commission may issue an order to show cause. And that is reflected in our Hawaii Revised Statute, Chapter 205-4, subsection G. These motions can be filed by an interested party. Oftentimes, well, as I said, it's rare that we have these orders to show cause. We've had only a handful in the last 20 years. We have had orders to show cause motions filed by the Office of Planning. We have had motions filed by other parties like the county, and we also had a motion for an order to show cause filed by the original petitioner as well, which was extremely unusual. And the commission itself can do it by its own action. The process that we follow is once we get a motion filed that's alleging that there's failures to perform according to conditions or representations of the petition's approval, the OEC holds a hearing on that motion. Now, there is another avenue for this to occur, and that is when the commission has asked or scheduled a status conference from a petitioner because we're not quite sure about what's going on with compliance with conditions. And they may come in and they may present, this is how we've been complying or not complying. And based on that, if the LUC has reason to believe there's been a failure to perform on those conditions or the representations and commitments, the commission itself will issue an order to show cause. And that order then gets transmitted to the petitioner, requesting that they appear for an evidentiary hearing to explain why the petition should not be reverted. And the LUC then basically we host I say status conference. It's an order to show cause conference. And we also have to advertise in the newspaper at least more than a month in advance to the public, indicating that we're having this order to show cause hearing. All the parties to the original petition, as well as the move on, because the move on is not always somebody who was an original party. So generally we have the petitioner, we have the Office of Planning and Sustainable Development, we have the county, usually represented by the County Planning Department. And sometimes one of those parties is the move on, and sometimes it's a move on who is an interested party outside of the original petition. All those parties will then present their case. The petitioner is likely going to be defending themselves, but they need to come and present a preponderance of evidence to show that they are in fact adhering to the conditions as well as representations as commitments enshrined in the decision and order. the end result is that after the commission deliberates on it, we either find that there's no violation occurred. And in that case, then we dismiss the order to show cause. Everyone goes on their way. Or we find a violation. If we find a violation, the commission tends to have a couple options. One is to move forward with a reversion. And that's what some people like to call the nuclear option that the commission has, because it's pretty, it's the worst thing that could possibly happen, probably from a petitioner's standpoint. Often what will happen, though, is that if we get to that stage, the petitioner will realize, wow, I really don't want the reversion to occur, but the only place I can go is the petitioner will ask if they can file a motion to amend, to make changes to reflect whatever change conditions they feel might be necessary. So that is an option that has occurred in the past. But the commission has often moved based on violation of conditions, based on an order to show cause, to revert a property.
If I can make a couple of comments.
Yep.
The really technically, when we file a motion for an order to show cause and request it to petitioner, the petitioner has the burden of showing why the property, why there has not been a violation, or why there is good cause for a violation. And sometimes we've had situations where the violation is a time failure to meet the time constraints set forth in the order. And the petitioner has been able to say, look, these are the mitigating factors. There was a recession, there was this, there was that, the property was sold. And it's not really that they say we're going to file a motion to amend. Under those circumstances, the commission actually renders a decision that instead of reverting the property, they're going to allow the petitioner to file a motion to amend. So that, I guess there's a real subtle difference there. On the one hand, the petitioner can't all of a sudden say, I'm going to file a motion to amend to stop the motion for order to show cause, but the commission can allow the petitioner to do that. So there's a slight difference there. They can't subvert the process by doing that. And then we do need to talk about substantial commencement, when you're done with this section. So.
Yeah, thank you, Dan. Before we talk about that substantial commencement issue, I want to point out, okay, this process there's multiple steps in the process. So the first thing that happens usually is that there's a motion made by someone. We call that person the move on, but that motion alleges that there's some violations occurring. So that first hearing that we have is based on that motion, and the move on, whoever it is, whether it's an interested party or it's one of the original parties to the petition, they've got the burden to show to the commission that, hey, the commission should have reason to believe that there's been some violations occurring.
As Scott mentioned, sometimes the commission, and this is what I think some of you may be familiar with, the commission, based on an annual report, may conclude that we need to bring a petitioner in for a status conference. And that's the way it'll be phrased. It won't be phrased a motion for order to show cause. It'll be phrased as a status conference. One of the options at that status conference, if the commissioners feel that there has not been, or that there may potentially be a violation, is then that serves as that first motion for order, motion hearing. In other words, if we do it on our own, we don't have to then file a motion on our own. We can just, the commission can request that the staff begin order to show cause proceedings.
That's a good point.
Chair Giovanni, this is Commissioner Chang. If I could just make a comment to add on. To add on.
Yeah.
Thank you. And I'm not too sure if Scott is going to cover this, but this is really sort of like the last resort. This is an extreme measure, but this is probably the only remedy that the commission has. So a lot of times, at least in those proceedings that I participated in, it may be asking the county to follow up on, what is the status of compliance with certain conditions. So, and sometimes, in many instances, at least that in my experience has been where the community members have also expressed concerns that certain conditions have not been met. So I think, and a lot of this I find is managing expectations, because I think a lot of times the community believes that the land use commission can do something about enforcement. But what I find our role to be in these instances is really as a convener to bring the appropriate parties to the table to address some of the concerns that have been addressed. And a lot of times it's been concerns raised by the communities. So, but we provide a process, a constructive process to have those discussions. But at least for me sitting on the commission, a reversion is the last resort without exhausting other remedies or considerations. Thank you.
And I think that's probably a good segue into getting into the discussion about substantial commencement, which I'll let Dan handle.
Can I ask one question though? This is Leo Higashi. I was wondering whether this process can be used in other areas like special use permits. For example, if we find that a county who wanted a industrial zone in the agricultural district under a special use permit, if we find that they didn't comply with the terms of the order saying that they would apply for a district boundary amendment within 5 years, could we institute this process for the purposes of changing or for the purpose of getting rid of the SCP?
I mean, that was kind of what happened in the Waimanalo Gulch case, where we denied the extension of the special permit, went up to the Supreme Court, came back down, and then we had to kick it back to the county for them to not so much amend their special use permit, but for further proceedings. That's the word that I was looking for, further proceedings. By the time it came back up to us, the special permit was long gone. I mean, it had, and the conclusion back then was that it wasn't really a reversion because the permit didn't exist anymore. Violations of special permits because of the county has primary jurisdiction, so to speak, over special permits would be with the county. So if there's been a violation, the county then has to look at it. If the county doesn't take enforcement action, then an interested party would probably bring it up to us. But at that point, it becomes more we don't have any enforcement powers with special permits, and this process really is not designed for that.
So what I'm getting at is that the problem that exists is that if the county gets a SCP,
Yeah,
and they're monitoring themselves,
yeah,
and they're saying, we don't have to worry because we're the guys who have the gateway. I'm just looking at this process as being a process that's applicable for the commission to take sua sponte up in order to show cause why that special use permit should not be reviewed, or what purpose of it.
Yeah.
So I'm just asking if that is
no.
possible.
Well, first of all, the reversion provision is in the section with regard to district.
No,
boundary.
but you can vacate a special use permit. It's just a permit. It's not a sort of entitlement of
Well,
like a boundary amendment. So I'm just using
yeah,
this provision as an example, or this provision as an example of how we can enforce special use permits, especially against the county who doesn't listen to us.
Yeah, well, yeah. The question then becomes, let's say we vacate the special permit, but the waste dump is still there. Or the permit expires and the waste dump is still there.
Then they're in violation.
Yeah, I mean, then it becomes a matter of it's a whole different scenario. You know, the private citizens could bring a lawsuit for violation, Sierra Club, in the case of Waimanalo Gulch. And or if the Attorney General decides it wanted to get involved, they could bring action. But we don't, the Land Use Commission doesn't have any ability to, once we, for the sake of argument, let's say we vacated a special use permit. After that, we're done.
That's fine with me.
Yeah. I mean, yeah. Okay.
Commissioner Okuda.
Thank you. Just to add to this discussion, I think order to show cause, yeah, you have to look at the substance of what's written in the order, but from the title, it's not necessarily prejudging what the remedy, even if there is a remedy, it's just show cause. In other words, I think the order initially is almost like two parts to it. One is just to bring the matter up in a public forum, and maybe there's a discussion then about what should be the remedy, but maybe and maybe the remedy is going to be something else. But the first step is always going to be, what is really going on? What's the factual basis? So I would think, unless there's authority contrary to it, that even if there isn't any specific authority, it's kind of like inherent agency authority to ask people, are you complying with what we've ordered? And depending on what the evidence is, which answers that question, then the next step is, okay, what's the possible remedy? It might be that Land Use Commission has no authority to do anything about it, but I think there is value just to bring the issue up in public so everybody can see that, at least we're paying attention to what we say, and it's not, so I think whether it's an order to show cause or some other kind of order, that's a valuable way of just making sure things are done as promised, whatever legal term we put to that.
And I'm not sure how the rest of the commissioners feel, but what I would hope is that we start. We're always talking about we don't have the enforcement powers, we don't have this and that to actually make sure that these conditions are met. What I would think is that, especially in other cases like SUPs, where there isn't a substantial commencement provision, is that those will be ripe for us to take a look at to determine whether or not they have been meeting the requirements under the SUP. And I'm just putting this out, and it says it may, I know it may increase the workload of everybody, but I was just saying that that's one mechanism of trying to enforce our terms or order. If at all, make them shame or something like that.
So, this is the chair. Thank you, commissioners, for your comments. So I, for one, feel similarly to Commissioner Ohigashi with regards to special use permits. And the example that I would give is if we grant a special use permit on agricultural land for a term of, say, 30 years for a solar farm, and after 10 years, there's no commencement of that solar farm for one reason or another, which has occurred, what is the process by which we could vacate that permit? And I'm a little confused by your answer, Mr. Orendenker. I wonder if you could, in that particular example, explain what options the commission might have.
Yeah, it's uncharted territory. There's no specific provisions in Chapter 205 with regard to our ability to vacate a special use permit. And as I said, one of the difficulties is that the county has primary jurisdiction. If that situation, excuse me?
continue on. I have a
If,
couple
if
of follow-ons.
if that situation did arise, we would have to get advice from the Attorney Generals as to how to proceed, because we haven't had that situation. Yeah.
Yeah,
So- So where I'm at is now where Commissioner Okuda is, which is in that hypothetical example I just gave, that I presume that, we may or may not eventually get to test the waters of whether to vacate the permit, but why couldn't we do a order to show cause and bring the whole issue to light with an LUC hearing?
Well, we could do a status conference. That would actually be the way we bring it up in public, would be to ask the petitioner to come in for a status conference.
Just turn on your button.
No, yeah, I got
But
it.
George has been trying to get our attention for a few minutes.
I was just wondering, can we vacate maybe half of a, the LUC has a large piece of land but what if they just decide that they're not complying for the Malka half or something? Can we take the half of that thing and, yeah, separate out the Malka versus Malka or something, and then say that they're not conforming to the thing, and so we remove half of the project from the thing. And can we do that? I
I
don't know.
believe that Chapter 205 provides that we can revert all or a part
Yeah,
of the
part. Right?
petition area.
So that's the way we could say, tell them, okay, we will vacate the upper half. That would be an option.
Mhm.
Yeah.
We haven't done that, and it creates a whole bunch of other problems. And then this segues us into the discussion on substantial commencement. Scott.
Sorry, I just wanted to point out, with respect to special permits, we have something that's similar and analogous to that substantial commencement, in that within a special permit, the counties are supposed to set basically a start date. From the time the special permit is issued, you must begin this use by a certain date. And therefore, the county has some enforcement ability if they don't start by that date. And the commission, has seen special permit motions to amend come in for time extensions because they have been unable to perform within that minimum start time. So I think
That was what I think Scott was explaining what I meant by the counties having primary jurisdiction. They take the first crack at it.
Sorry, Commissioner Giovanni, I'm just going to make one comment. I think, Scott, I appreciate that comment. I think some of the concerns that we've had come before us, it's been that the community hasn't had, because they have raised the issue of whether the county is enforcing. So there is, I think all of us are looking for a platform to permit, in particular, community members to raise issues. Whether the Land Use Commission is the appropriate forum, I'm not sure, because we do have limited jurisdiction. But I think, at least I know in a lot of state lands or leases, we do include, or permits or licenses, a provision in one of the terms in there is our ability to revoke the license or the permit or failure to comply. So I would hope that perhaps we can explore this with the Attorney General. What are our potential options, as we have seen an increased use of the special use provision for activities that we've had questions about. Thank you.
Thank you, Commissioner Chang. Let me also say, this is the chair speaking, that in the most recent term of this commission, in consideration of some special use permits that came before us, we included conditions. This is a segue to the discussion on substantial commencement, but we have included conditions by which the projects would go forward on a timeline, and indicated that failure to comply with that condition would be a basis for enforcement by the county. And I would encourage this commission to consider conditions such as that in future considerations of special use permits that come before us. Make it easier for the county to enforce.
Thank you, Chair. And once again, segueing into a short discussion on substantial commencement. As you may have heard me talk about yesterday, substantial commencement is not clearly defined. But from a procedural standpoint, when you're looking at orders to show cause, the first question is whether there's been a violation. If the commission finds that there's been a violation of a condition or a representation, then the next question is, has there been substantial commencement? If there's been substantial commencement, if the commission believes that there's been substantial commencement, and petitioners who are faced with motions for orders to show cause and a possibility of reversion always argue that there's been substantial commencement. But it's a factual finding by the commission as to whether or not the activity by the petitioner amounts to substantial commencement of the project. If there has been, then the commission has no further ability to enforce. If the commission concludes there has been substantial commencement, then the only enforcement entity that is able to enforce is the county. If there has not been substantial commencement, then the commission can proceed to making a determination as to whether or not it wishes to revert the property or whether to allow the developer to undertake a motion to amend. Once again, as we discussed yesterday, I can't tell you what substantial commencement is. It's based on the facts. The Supreme Court hasn't given us a clear definition of what substantial commencement is. I watched Brian argue it at the Supreme Court years ago. And although Brian's arguments were very logical, the Supreme Court's decision, if you ask me, was kind of emotional. You know, it was, oh my God, they've spent $40 million. That has to be substantial commencement. Well, the project was $750 million. So $40 million really was a drop in the bucket. But anyway,
Legal fees only.
yeah, but it is what it is. But the reason that I bring it up once again is that that's kind of the analysis. First, has there been a violation? Second, has there been substantial commencement? And then third is, if there hasn't been substantial commencement, then are we going to revert or are we going to do something else? Okay.
Just to clarify, Dan, Mr. Orendaker, Brian you're referring to is Mr. E?
Yes, that's correct.
Yeah, let's try to, for the purposes of our record, let's try to refer to each other for clarity by including last names. Thank you.
Thank you, Mr. Chair, for correcting me.
Chair Giovanni, this is Commissioner Chang. I just wanted to add to Dan's comments about substantial commencement. It's been sort of my experience sitting on the Land Use Commission. Because this issue there's not a lot of clarity, and I don't think any of us choose to go up to the Supreme Court to ask them to clarify. So I think the land use commissioners have been much more diligent about including on their conditions specific timeframes. I know that Chair Giovanni has talked about asking the petitioner to quantify what's a substantial commencement. But I think it has become incumbent upon the commission that when we are proposing conditions, that we are making them much more specific, and so that you can quantify them and you can easily evaluate whether they have commenced or not. But I also want to comment, because I think, George, you made a comment about Malcolm Mackay. Part of the challenges that we've had with this particular provision is if it's been determined that they have substantially commenced even on a portion of the project, and the entire DBA is one, is defined as a project, we may have a very difficult time bifurcating unless they have agreed to. And at times they have. We have had situations where they have come forward to bifurcate because there actually have been two developers. But I think a lot of, at least in my experience sitting on the commission, also being a lawyer, not wanting to go up to the court to litigate issues because of the uncertainty when it comes back down, is that we are all trying to be much more proactive in the conditions that we're preparing, so that it is very clear when someone has complied or not complied, whether it's substantial commencement, but it is ensuring that our conditions, it's not vague, it's not ambiguous, but there's no dispute in what our intentions are. Because a lot of times we are reviewing actions that a previous commission has made at times 20 years ago, and trying to understand what were their intentions, but also trying to to maintain the integrity of those intentions has been difficult. So I think it is, I just find that it is in our best interest collectively to make our conditions, and in particular, our findings of fact that support the conclusions on the conditions very specific. So thank you.
Commissioner Chang, this is the chair, and I fully concur with your suggestion / recommendation, and encourage this commission as we move forward to include as much specificity in our orders as appropriate and as possible. It will only help with the entities that have the job of enforcement, and it will only help future commissions interpret the original intent of our decisions that were made at this point in time. So thank you, Commissioner Chang. Very, very much on point. Thank you. Back to Mr. Orendaker. I'm not sure where we're at.
Commissioner Cabral here, Chair, if I could say, I think I'm trying to listen and speak less, but having gone through a number of these hearings over my past years, it seems like the mess is that the land, when it was okayed by the prior land use commissions 20-25 years ago, it was a whole different world. Things were different. The properties often have gone through foreclosure, have been purchased and re-foreclosed and re-foreclosed. And here we are, 25 years later with a whole different world, different developers, it's gone through so many different changes. And I think we're going to have to keep dealing with this lack of any kind of common sense until possibly we go to the legislature, or somebody goes to the legislature and tries to have some clarity put to some of these rules. And I'm not sure that'll ever happen because of funding, and it's not something anyone thinks is important as a legislature. It doesn't make news and that. But anyway, just my 2 cents is I think we're going to continue to have these problems dealing with old decisions of the commission, and there's probably just thousands of lots out there. We know if we've got 40,000 lots out there, then there's a whole lot of them in these subdivisions that are going to continue to be problematic until they get developed or cleaned up or something. So anyway, I don't know that there's funding, but common sense has gone awry here. So anyway, that's my 2 cents. Thank you.
So Commissioner Cabral, thank you very much for sharing your 2 cents, which is always welcome. And bringing some common sense to the discussion. So do not hesitate.
Chair Gary Okuda, if I may.
Commissioner Okuda, you're recognized.
Thank you. I believe what Commissioner Chang is suggesting makes a lot of sense, especially in the appropriate case again, to look at specific development timelines. But, and her suggestions are consistent with what the Supreme Court said in the case that lays out all of this issues with respect to reversion and substantial commencement, which is the DW Inalea versus Bridge Inalea case. And what the Supreme Court said in that case is I don't want to call it the evil, but the harm that we're supposed to avoid is where a landowner gets a boundary redesignation to urban. Just the fact that there's this redesignation creates value for the land, and the landowner, however, does not keep its promises to the community, whether it's the development as promised, the affordable housing as promised, protection of water or other environmental resources as promised. So in other words, promises are made, the landowner gets the zoning to urban. That just creates value, and if the promises aren't kept, it allows people to speculate. So I believe what Commissioner Chang is suggesting is definitely a good way to mitigate against, I don't want to call it the evil, but the harm that the Supreme Court in the case said we are supposed to work to avoid, which is basically land speculation with no concurrent benefit to the community. Thank you.
Thank you, Commissioner Okuda. Any other commissioner wish to comment at this point? I cannot tell, so Mr. Derrickson, help me recognize them.
I think that's it, Chair. A couple of quick statements with regard to that before we move on. First of all, I agree with Commissioner Chang's specificity with regard to conditions is very important and very helpful. However, specificity does not prevent substantial commencement. No, I mean, you can be very specific and with regard to a condition, and substantial commencement could have occurred for other reasons. But I have to point out that the real lesson from the Bridge Inalea case, if you looked at what happened factually, is that it's now, in that case, the commission was, for all intents and purposes, trying to work it out with the developer and saying, you know, okay, if you do this, then we won't revert. If you do that, we won't revert. We can't do that. You know, it's at the time that we hold the hearing, it's all or nothing. You can't say, you know, okay, well, we'll hold this at bay and see, you know, how you handle this, or if you do this, then we won't. It's all or nothing. You can't. We don't have any negotiation powers with the developer anymore. If we decide that we're not going to revert, if we want to give the developer a chance, then we may very well, in fact, be giving up our ability to revert. So
Don't even enter. Don't even start the dance.
okay, I'd like to move on to the next topic, which is boundary interpretations. And we just put this in here. We haven't gone over this before. Mainly because we've had 3 of these in the past couple of years come up to us. Boundary interpretations are usually handled completely internally. We have a drafting technician, you all know Fred, or may know Fred. And basically what's happening with boundary interpretations is, for one reason or another, whether it be with regard to something they're building or with regard to some permit that they're requesting from the county, a landowner must determine exactly where the line is between conservation, ag, or urban on their property. The way they do that is that I certify a map that Fred produces showing the exact line. Some of the boundary interpretations are not that easy because the original boundary was set using what available technology there was in 1960. And so we have to not reinterpret, but we have to examine what was said to see how close we can get to exactly what they were saying. Usually this is not a problem. Recently, we've had some issues with regard to our boundary interpretations. And if a landowner disagrees with our interpretation of exactly where the boundary is, they have the ability to ask for a declaratory ruling from this commission on whether or not the boundary interpretation that we have issued is appropriate. It's extremely fact-based. The recent hearings that we've had on this concern what was meant by the commission back in 1967 or 1974 when they did their boundaries, which is very difficult to do because we have to go back to old records and try and figure it out. But we don't see many of those. I think it's an aberration that we've seen some recently. We're hoping that we don't see many more. Anyway. Okay, now the next section that we've got is decision-making in the public.
This is the chair. Just to for clarity, when you say it is those matters are typically managed or handled internally, you mean by staff without the involvement of the commissioners. Is that correct?
That's correct. Technically, the Land Use Commission is the authority holding the maps that determine where the boundaries are. And those are theoretically set. And all we're doing is we're producing maps pursuant to our records. And as I said, sometimes the maps are based upon topopoly or something like that, that may have moved, may not have moved. Topopoly was never specifically designated. It's a camel hump, whatever, you know. And so that's the drafting technician has to use his knowledge to make a final determination as to exactly where that boundary line is.
Thank you.
So it's not anything that the commission decides. It's a pretty much fact-based decision.
Yeah. Okay, proceed.
Okay. The next section is decision-making in the public hearing process. And very quickly, we'll go over a lot of things that the commissioners may already be familiar with. As Attorney General Chena pointed out yesterday, we're kind of an interesting hybrid. We're subject to Chapter 92, which is the Sunshine Law and the Uniform Information Practices Act, but we hold contested case hearings, which is kind of unique or very rare in the state system. The Sunshine Law in brief says that all meetings must be noticed and an agenda posted. It has to be done a week in advance. So if you have something that you want to put on an agenda that you want to bring up for the next meeting, you have to get it to us at more than a week in advance. I would advise the commissioners to let us know well before that week comes up because we have to do a mail out and produce things. Hearings are open to the public and minutes are taken as well as a recording of the proceedings. And as you know, we do transcripts as well. The public has to be given the opportunity to testify, and we've discussed that. And now it must be done not only at the beginning of the hearing, but at the end. The public testimony could be limited in time when it's taken during the hearing. You know, some good examples are Olawalu and some other cases where we had 200 people testifying and we limited them all to 2 minutes because we never would have gotten through it otherwise. The other part of the Sunshine Law that's very important, and as we've discussed, is that all deliberations must be made in public. There can be no deliberations toward a decision in executive session or in a separate meeting. And as I said, this is very, very important. And the commissioners shouldn't be shy about expressing their opinions in open session. It's important, and what their thought process is. Executive sessions have to be by motion. It's very important to keep in mind that more than 2 commissioners are prohibited from meeting without notice. Staff's not decision makers, so we're not subject to that restriction. So you can feel free to talk to us at any time, more than one of us, about a petition if you have questions or concerns. 5 members are needed for a quorum. That's a majority since there's 9 of us. But 6 affirmative votes are needed for any action concerning a district boundary amendment or decision in order on the district boundary amendment. As a practical matter, if what's in front of us concerns a district boundary amendment, we try not to hold a meeting with less than 7 commissioners. Because if there's only 6, any decision has to be unanimous. And that makes petitioners very uptight. Okay, so, but what's the basis of your decision and what's the decision-making criteria? There are several sections in the rules that cover the decision-making criteria for specific types of petitions. And those are set out there, and I urge you to take a look at them. Staff will remind you, both in our staff reports and in discussion, what those criteria are. But in addition to those criteria, there's the general requirement that there be good cause shown and that there be a preponderance of the evidence with regard to your decision. The preponderance of the evidence requirement is really one that's more about, given everything that's been said, what's more likely? What has been shown? What has been proved? What are we confident of with regard to the facts? Slide 20, this is 205-17. This is the criteria with regard to reclassification for a district boundary. Pursuant to this chapter, the commission shall specifically consider the following. And I won't read them, but this is the list. When we draft a decision in order, we will go through all of those in the decision in order to ensure that all of these criteria have been met. And the Office of Planning and Sustainable Development is critical in helping us with rendering a decision on this because they will present evidence with regard to these criteria.
So Dan, this is the chair. Mr. Arnett, could you speak a little bit about the circumstances by which this commission must rely solely on the evidence in the record to make its decision?
Yes, I touched on that yesterday. Once again, the commission's decision must be based on what is presented to it. It cannot be based on things that the commissioners might know. I mean, let's face it, Hawaii is a small state. You hear things with regard to a petition that may not necessarily come out in the course of a hearing. If that information doesn't come out during the course of a hearing, you can't say, well, I'm not going to vote for this because I heard so and such and such. The evidence has to be in the record. Now, does that mean that if you've heard something, you can't get it into the record? No. I mean, you can get it into the record, but you can't just blurt it out. What has to happen is you have to ask the petitioner or the witness, do these circumstances exist? Do they not exist? What is your financial situation? Whatever the situation revolves around, you can question the petitioner with regard to what you know and try and get it out on the record. Of course, if the petitioner denies it, then you can't say, well, I know different. There has to be somebody to support you. Your conclusions, or there has to be some testimony to support your conclusions, or some evidence to support your conclusions. It is not unheard of for the commission to request that a witness be brought back for further questioning. So if something doesn't come out and then you realize that you need to get that out of the witness or the petitioner or the Office of Planning or the county, you can ask to have the witness recalled so that you can question them with regard to that matter. But it's kind of you have to be cognizant of the fact that it's a little bit of an art sometimes to get the information out of the the witness that you want. If you have concerns about how to do that, staff is here to help you, to direct you as to what type of questions may assist you in getting that information out of a witness or a petitioner. And I would urge you to utilize us as a resource to assist you. But once again, you have to base your decision on what's contained in the record.
Chair Giovanni, this is Commissioner Chang. Can I make a comment?
Please.
Yeah. Thank you, Dan. I think in addition to the decision-making, one thing that comes up regularly is disclosure to ensure that there's not a conflict of interest. So whenever we've got when a matter on the agenda comes up and we may know a party, we may know one of the attorneys, the chair will usually ask if the commissioners have any disclosures or conflicts of interest. To maintain the integrity of the decision, it's really critical. And then if many of us will make a disclosure, and then the chair will go around and ask the parties if they have any objections to the commissioner continuing to participate in the proceedings. If there is indeed a conflict of interest, then that commissioner will not participate in the proceedings at all. So I think it is really important that, we all and kind of goes back to Dan's comment about this is a small community. I mean, inevitably, we know many of the people that come before us. So it's always good to take the lead of Commissioner Okuda is probably the best at disclosures. But it is always, I find it is better to err on the side of making a disclosure than later on to come back and having to, one of the parties say, hey, but this person used to. So that I think is important as part of the decision-making, is making sure that there's full disclosures of any potential conflicts of interest so that it's on the record and there can be no dispute about, the decision at the end. Thank you.
Thank you, Commissioner Chang. We'll be going over, have an ethics section too, that we'll go over. That's okay. Okay. Okay.
Chair, I have again, my common sense to our new commissioners in particular. It's so wonderful to have 9 commissioners. For a long time, we only had 8. So to get down to 7 was really easy to happen, and to get down to 6 occurred. So of course, we had those couple of years of COVID where things were always on Zoom. And now we have the luxury of having the combination of in person, which I think is preferred for discussion purposes. But as our chair is on Zoom, we can also do that. I have made it a real priority, again, out of my common sense brain, to try and be available and make all of the hearings, because I've realized over the years how difficult it is when this starts to happen, because if we don't have that necessary quorum or that necessary number, the whole thing might have to be canceled, or it really puts a whole lot of people into a tailspin, I'm sure, with the staff. So I have really tried and asked you folks to look at that as a real priority. I know your paycheck may not appreciate it, but but instead, even when I travel before those days or whatever, so that I can be available by Zoom nowadays. So I just want to make that again as something to pay attention to, because you've got 9 busy people here in Navarre, and I apologize, I have to leave early today. So, thank you.
Thank you,
Mr.
Commissioner
Chair.
Cabral and Commissioner Chang.
Mr. Chair, Leo Higashi.
The chair recognizes the esteemed commissioner from Maui, Leo Ohigashi.
I have a question. We all know that it takes 6 affirmative votes to pass anything, right? To pass the kind of boundary amendment. Does it take 6 affirmative votes to deny a boundary amendment?
Okay. This is where things get messy. The answer to that is no. I mean, we could end up with a 5-4 vote failure, and that would the motion to affirm would fail to pass, or to grant the petition would fail to pass. So technically, the answer to that is no. From a practical standpoint, it becomes very difficult for us to prepare findings and a decision in order, because we don't have a decisive decision by the commission. So in those circumstances, if a motion fails to pass in the affirmative, we would hope that one of the other commissioners would make a motion to deny, and we would obtain 6 votes to do that.
I think
Of
that-
course, the commissioners are free to make their own decisions, but we would urge the commission to somehow reach at least a consensus of 6 to go in either direction.
And that was my recollection of what happened in Waimanalo Gulch, that we weren't able to get the necessary 5 for either affirmative or even a denial, right, of the permit or vacation of the permit. But eventually we're able to get 5 for a compromise position. So what I'm understanding is that the commission it's recommended by staff that we attempt to reach a 6 decision, whether or not it is.
That's correct. Yeah. Staff really would really appreciate that.
This is the chair. I just want to echo a couple of points regarding the most recent discussion among the commission and staff. And it has to do with transparency of this commission. The fact that we deliberate publicly is, to me, something I'm very proud of for this commission. It communicates to all parties and to the community at large where we're coming from, and that's so important. And consistent with that, being very transparent about disclosure and as Commissioner Chang was speaking to, is just another part of that process in which this commission operates with full transparency. And I think that's an attribute that we should be proud of and continue. Okay, back to you, Mr. Hardleger.
I'm going to jump to the ethics section since we're on it already, and it's fairly brief. The state ethics code is chapter 84.
Just a quick time check. Should we take a break after the ethics session? That would be just over an hour.
That's, yeah, okay. That's fine, Mr. Chair. The State Ethics Code, Chapter 84, HRS, governs how the ethics for the commissioners. And let me point out that that's different from disclosure. Okay, so basically with the ethics code, what we're talking about is whether or not you have a conflict of interest. And the way that's defined in the ethics code is whether you or someone in your family would benefit monetarily from their decision or benefit financially from your decision in some manner. Just for everybody's knowledge, that there was a Supreme Court case with regard to union representation on the fact that a union is going to benefit from a decision doesn't require the recusal of the union representative in those circumstances. That being said, if you believe that you may have that type of a conflict, you should contact us and contact the deputy AGs, and we'll direct you to the right people to make a determination as to whether you do in fact have a situation in which you must recuse yourself. Unfortunately, a lot of times it's a gray area. And what we've said urge the commissioners to apply, the standard that we've urged them to apply is whether there's an air of impropriety. If they remain a decision maker on a particular petition. And what that means is that, as Arnold would put it, just doesn't look good. And so, once again, if you feel that you have a situation, you should talk to staff and we can help you through it. And if you feel that you have a conflict, then you may recuse yourself. You can do that at the hearing. You can do that ahead of time in communication with the chair. The thing about recusal is that it doesn't mean, okay, so I recuse myself from this. Now I'm going to sit back and watch. You got to leave. You actually have. You can't even be in the room. You have to walk away from the hearing. Now, the interesting other part of ethics, the ethics situation, is the one that Commissioner Chang brought up, and that is disclosures. Once again, small community. We have different relationships with different people. We may know people involved with a petitioner. And we may have a relationship with an organization that is a party to a proceeding. It's always good to let everybody know. We've had things from, I sit on the board for the Hawaiian Land Trust, which would benefit from this project if it passed, to I've been to Japan and, gone traveling with the attorney for the petitioner many years ago. But it's always good to disclose, even if you think, hey, this isn't going to affect anybody. Nobody should really care about this. But if you have some kind of relationship or there's some connection between you and one of the parties, the petitioner, or somebody related to the parties or the petitioner, it's always good to disclose. So we've had commissioners disclose relationships with public witnesses, just so that everybody knows that it's out there. If everybody knows it's out there and none of the parties object to the commissioner continuing after the disclosure, then at least we're upfront. There have been a couple of times, at one time in particular, where allegations were made with regard to a relationship by a party that we determined were irrelevant. That occurred in the Waimanalo Gulch case when one of the interveners tried to get various commissioners to recuse themselves because they were members of the Sierra Club. And we concluded that there was really no reason to do that. Anyway, so that's very quick ethics. And once again, if there's any question in your mind, we urge you to contact staff.
Chair, this is Commissioner Cabral again with more common sense. This comes up a lot, and like in Hilo, we have had so many developments, so we don't have a lot of important hearings there that are, anyway, very exciting. And the one biggest one, which was the Connection School, I couldn't even sit in on it, and I did consult with staff because I said, I'm not biased. I could make an objective opinion. So it was really good for me to be able to call staff ahead of time and reveal what my connection was. And the fact that I got paid money for managing their building every month meant that I couldn't sit in on the hearing at all. I mean, I just didn't even attend because I could not make a ruling. And so my attendance even. So it's best to, if you think you have any connection ahead of time, let staff know, let Dan know. And then he can help make that determination, as opposed to having that sort of drug out at the hearing, the beginning of the hearing, and then everybody starts to think, what is this? So anyway, communication, common sense. Thank you.
Thank you, Commissioner Cabral. I just want to clarify, when you said let staff know, let Dan know, that's Dan Orendanker, not the chair.
Yes, thank you. Sorry. Yes, there's two of you.
And Chair Giovanni, if I can make one comment, since we're talking about ethics and sort of just kind of legal processes. It's ex parte communication. There have been instances where we're in a proceeding and one party totally unintentionally sends a commissioner some information, and another party alleges ex parte communication, which then created a conflict. So we just have to be very careful that we're not even getting emails from parties. We're not communicating with them. and like, like I said, Hawaii is a really small place. So we have different relationships with people. We just have to be very conscious that when we are meeting them outside the context of the hearing, we're not talking about the project, but the ex parte communication continues all the way until the case has been closed. So just be cautious of that as well.
We do not give out commissioners emails. We don't give out their phone numbers, even when they're asked. So you can be assured that if somebody's contacting you, it's, yeah. There's a couple of other things that I want to point out. Very often you will get emails from us that will contain, a heading that go to all of you all at once. Don't reply all. Okay, because that's kind of a violation of the Sunshine Law because you're communicating with more than one commissioner. Reply to staff individually. If you get an email like that and you have a question, don't hit reply all.
I have a question, Mr. Chair.
Sure.
A question, a comment, actually, but
Commissioner,
if I
Hayden,
might.
yeah, please.
yeah. The question is that I've always wondered where the requirement of getting yourself out of the room when you declare a conflict or not appearing at a hearing or not having any kind of presence at a hearing, where does that requirement come from? Because I noticed that other bodies, they don't require it to be taken out. My comment is that the slide before this, the ethics slide, I'm thankful that you used my high school graduation picture. But
It's an AG opinion. It's an AG.
Yeah, that's what I was going to say. Is the Attorney General had advised us.
is that because we're a quasi judicial, and that it's sort of like having the juror not present because they have a conflict or something like that?
Well, I think it's actually because they recognize that our commissioners are really good at giving stink eye, so they can sit in the back and, I'm not sure what.
The baseball.
This is the chair. Chair recognizes Ms. Chena.
Yeah, that advice applies to all boards and commissions. In general, you're not supposed to, once you recuse, you're not supposed to stay in the room. How much it's enforced, I don't know, but in boards and commissions that, I've advised, it's get out of the room. The other thing is that if you want a really quick take on whether or not there is an ethical conflict or something like that, the Ethics Commission, Office of Ethics, has an attorney of the day that you can just call to get a quick take on it. And their phone number is 808-587-0460. And, so it's an attorney who will give you advice if you have a question. And, it's confidential and you can just, ask.
Thank you.
Chair, Gary Okuda.
Yes, Mr. Okuda.
Thank you, Chair. Regarding the attorney of the day, let me disclose that I think one of the attorneys there, Virginia Chalk, used to work with me at the old law firm, Okamura Takushi. But leaving the room, I believe is consistent with the rule that the Supreme Court set in the Mauna Kea 2 case. The issue there was, should the hearings officer who was acting in an administrative capacity for the Board of Land and Natural Resources, retired Judge Ricky Amano, did she have to recuse herself under certain circumstances that were presented? And I think the Supreme Court said two things. One thing is you have to look at the statute and see if the statute or rules mandate or require or suggest a recusal. But there's a second part, which is, to put it in plain English, I think is does it look bad? Is there an appearance of impropriety? And so, and the Supreme Court said in Mauna Kea too that the standards that apply to judges essentially apply in that kind of situation. So based on the fact that I think the standard that applies to us based on Mauna Kea too is what would be required of a judge, it's I think a two-step evaluation. One is there a specific statute or rule that requires the recusal? But the second thing is there an appearance of impropriety? Does it look bad? And you were talking about the Hilo Charter School. Well, one of the reasons why I recuse myself, and this might or might not be on the record, but I don't mind it being there, is the fact that one of the lawyers involved in the proceeding is basically on the same side of a case that I'm involved in. And even though it did not appear that that would necessarily be a specific statutory violation, frankly, it just wouldn't look right. So I think that's a two-step thing. But I think leaving the room is consistent with the rule that we should avoid appearances of impropriety. Thank you, Mr. Chair.
Thank you, Commissioner Okuda. Yeah, I would agree that conflicts of interest can be real or perceived. And in some instances, a perceived conflict of interest actually is greater concern and should be a basis for recusal, but certainly a basis for disclosure. So I'm looking at the clock, Mr. Orndecker, and I'm inclined to take a break at this point in time unless you recommend differently.
To be honest with you, Mr. Chair, if we can keep powering through this, because we've got Office of Planning and Sustainable Development is supposed to give their presentation at 11. So we've got two sections that we've got to complete before then. One of them is in with regard to intervention, and the other is with regard to the public trust doctrine.
So please, so then proceed, power through. We also need to take community testimony if there's anyone present and wishes to do so before we entertain the Office of Planning.
Okay, thank you, Mr. Chair. Go ahead, Scott.
Okay, this is Scott again. I'm going to cover intervention. I'll start by reminding the commissioners that, particularly with respect to district boundary amendments, there's three mandatory parties. Whoever it is that's petitioning, the Office of Planning and Sustainable Development for the state and the county. Those are the parties. Now, interested persons or organizations can intervene, and there is a process by which they can do that. When we talked about district boundary amendments, we indicated that there's an initial petition that's filed with us. And along with that, there's a notice of that filing in the public. That triggers the first 30-day opportunity for an interested party to file a notice of intent to intervene. Basically, they're letting the petitioner know, they're letting the Land Use Commission know that, hey, we think we want to intervene and become a party. So heads up. And what that does is now the petitioner and the other parties, Office of Planning, Sustainable Development, the county, if they file anything, they will have to file a copy to these folks who have given us this notice to intervene. So we've got down there that the intervention is allowed for district boundary amendments and declaratory rulings, but not special permits. Why not special permits? As I pointed out before, when we talked about special permits, really the action occurs at the county level for special permits. Remember, it comes up to us afterwards. The evidentiary hearing occurs at the county level. And so the parties are established at the county level. So when it comes up to us, no new parties are accepted. That doesn't mean that the public and interested parties cannot participate by providing public testimony, and they do. It's just that we don't go through a process at our level to allow new parties to come in because we're not accepting new evidence. Next slide. Okay, so who can intervene? This shall be admitted. Basically, any department or agency of the state, any department or agency of the county in which the property is situated can ask for intervention, and it's granted. Anybody with a property interest who resides on the land, that could be somebody who, you know, there may be more than one owner of a piece of property that's being considered for a petition. That last one, all other persons may be admitted. Usually when they can demonstrate that their interest is clearly distinguishable by one of the other parties that's taking place already. And, you know, often we'll have intervention sometimes we'll have intervention by a department, such as the Department of Education, because a petition is going forward and they feel that they want to protect their interests over and above what might be covered by the State Office of Planning. Go ahead, next one. So intervention, this commission has been very liberal with granting intervention because we want to make sure that anybody who is willing to go through the process to become a party and to file and to present expert witnesses to cross-examine should be allowed. We can deny if the position of the proposed intervener is, if we determine that it's about the same as one of the parties that's already there, and that, or that if we allow these, you know, one or more interveners, that it's going to render our proceedings inefficient or unmanageable. And then we can also deny it if the request is untimely. I think we have one more slide. Okay, this is just how intervention works. I will say that the commission can limit the scope of intervention. There may be an intervener who says, you know what, we are the Society for the Preservation of the Hawaiian Butterfly. We're really concerned because of the habitat might be impacted here. And we want to intervene. And if the commission says, okay, look, we're going to allow your intervention, but we are going to limit the scope of your intervention to just addressing the issues surrounding the habitat of the Hawaiian butterfly. We're not going to let you get into traffic mitigation measures or school requirements or affordable housing requirements.
Chair Giovanni, oh, Scott, did you have something more? Okay, Chair Giovanni, this is Commissioner Chang. If I can just add to that.
Please do.
I think the commission, in my experience sitting, we have been very liberal with allowing intervention. I mean, a lot of what I find that we do is how do we minimize risk on appeal? So it's better to have people at the table. But there have been interventions granted because they would be helpful to the commission. Let's say they represent a community group or they represent the interests that may not necessarily be represented by one of the parties. And what is really helpful about that is the burden's now on those parties to present all the evidence, but they participate as all other parties, they get to cross-examine, but we also hold them to the same standard as the party. Some of the interveners come in as pro se, but they are expected to participate and as do all the other parties. But we have been rather liberal with allowing interventions, especially if it's going to be helpful to the commission in our proceedings.
A couple of things about intervention, a couple of comments. Number one is that I have never seen the commission deny intervention. And that's just because of what Commissioner Chang said, we want to make sure we get everything on the record and we minimize the potential for appeal. The other thing is that intervention can really make a mess out of things. We have had interveners come in the day that the hearing's supposed to start and say, we're filing a motion to intervene. We actually have to, with a motion to intervene, we actually have to agendize it, hold a hearing on it, render a decision on whether we're going to allow the intervention, and that can reset the clock. It can move everything to a different time frame, and all our timing with regard to when we were going to schedule the hearing and when we were going to hold hearings gets thrown out the window. It makes everybody crazy sometimes, but it's one of those things that we have to deal with. Now I'm going to go very quickly over the public trust doctrine. And one of the reasons that I'm going to go over it quickly is because, as everybody may be aware, we took the opportunity to record a presentation by Jonathan Schroyer, who teaches public trust doctrine, a course on public trust doctrine at the University of Hawaii. And that is available to the commissioners to see. It's online. Ariana can help you find the link. It's actually on YouTube, but we have a link to it in the commissioner's checkpoint. So a very brief overview of the public trust doctrine. The public trust is the right of the people to have the waters protected. This is from the Waihole water decision, and this was concerning water. Comprehensive resource planning is intrinsic to the public trust concept, which also demands provision for traditional and customary Hawaiian rights, wildlife, maintenance of ecological balance, and scenic beauty. So basically what it's saying is that cultural resources, water, and the general environment are subject to the public trust doctrine. This is further bolstered by the Hawaii State Constitution, Article 11, Section 1, and you can see what it says right there. All public natural resources are held in trust by the state for the benefit of the people. And we'll talk about what that means in a minute. It's very different from a mandate to mitigate impacts. Mitigation of impacts are saying, okay, we're going to lose this, but we'll do this to make up for it, or we'll minimize the impact. There's an affirmative requirement to ensure that public trust resources are preserved for future generations and that decisions do not overly impact the public's right to utilize those resources. That's the requirement for a trustee. You're looking at the resources, not so much in terms of, well, this is only a minor impact and, so what? It's, look, this has to be preserved for the future, for everybody. So if there's any question in your mind as to whether or not this public resource is going to be negatively impacted, then, you've either got to craft a condition that maintains that public resource, or we got to deny the permit. It's not, you'll see in a minute what the Supreme Court has said with regard to that. The first priority must be the long-term protection of the resources. The first consideration must be the long-term health and sustainability of the resource. When there's, as I just said, when there's a doubt about the impact of the resource, the agency should err on the side of caution. Watershed protection, historic sites, cultural protection, environmental natural resources, air, minerals, and energy resources are traditionally within the public trust doctrine. For the LUC purposes, the public trust doctrine is compounded by federal environmental regulations, which may go beyond what we consider the public trust. It covers up we gotta fix that somehow because it's covering up some of the language. In addition, public resources are inextricably interlinked with the right to traditional and customary practices. Without the resource upon which to practice, there can be no practice. Okay, hold on a sec. Okay. There, okay. Thank you, Martina. Once again, the state must act as a trustee and not simply as a good business manager. And this is the famous quote: it must not relegate itself to the role of a mere umpire, passively calling balls and strikes for adversaries appearing before it, but instead must take the initiative in considering protection and advancing public rights and their resources at every stage of the planning and decision-making process. Once again, from the Waihoe case. Before we get into Kapaakai, which is another resource, what the Supreme Court is really saying here is that there's an affirmative burden on the part of the petitioner or the agency that's impacting the resource to show that they're not going to harm it. You know, if they don't come forward with evidence that they're not going to harm the resource, then you can't say, well, I don't think they're going to, so let's let it. No, you know, they have to affirmatively show that they're not going to harm the resource in the long term. Yeah, yeah. Kapaakai case, you'll hear us talk about it all the time, staff and some of the commissioners who've been on for a while. There has to be a Kapaakai analysis in every one of our petitions. And basically Kapaakai says that the state and its agencies are obligated to protect the reasonable exercise of customary and traditionally exercised rights of Native Hawaiians to the extent feasible. We're obligated to make an assessment independent of the developer or the applicant of the impacts. The independent assessment must include 3 factors known as the Kapaakai framework. Here they are. Identify valued costs. In other words, identify it and the extent to which traditional I phrased wrong. Traditional are exercised. The extent to which those resources will be affected, and the feasible action to be taken to protect rights. And Jonathan, in his that little YouTube video, has a very concise way of putting it. For more information on the public trust doctrine, refer to Dr. Schroyer's presentation. We urge you to look at that. It was very well done. People who participated in it, the commissioners who participated in it were very moved by it, and it was very helpful. And go back and look at it again and again. It's very helpful. The next topic.
Wait, can I, sorry, Chair Giovanni, if I can add to Dan Ordenker's presentation, I guess I want to emphasize that we have an affirmative duty as the commission, like the Board of Land and Natural Resources, like a planning commission. The decision makers under Article 12, we have a constitutional obligation to preserve and protect traditional customary practices exercised by Native Hawaiians, subject to government regulations. So there is a balance, and the burden is on the applicant. And the applicant must provide us sufficient findings, sufficient information for the commission to make findings and conclusions to support whether traditional customary practices will be adversely impacted. If there is insufficient evidence, I do believe that the Supreme Court and the Constitution requires us to deny the permit. It is unlike most other, as Dan was talking about, other mitigation measures, traffic, even protections, traffic, other kinds of impacts. that's not a constitutional obligation that we have. And the Supreme Court has expanded what is the public trust, even in the Mauna Kea case, the Pohaku Law case, that, and we will get sued if we don't comply with that. So I find that it is really important for us to make sure that we are placing the burden not on the community, but on the applicant to come forward with sufficient evidence to support its ultimate conclusion. That conclusion is not made by the applicant, whether they're going to harm their resources or not. That is really a burden upon the commission, but we have to make sure that the applicant has provided us sufficient information. Many a times, in particular with Article 12, Section 7, Native Hawaiians, you have Native Hawaiian practitioners who come forward and they raise the issue. I do believe that we have a responsibility when those issues are raised, whether it's in the record or at public testimony, to have the applicant address those issues so that we can make an adequate finding. If not, I believe that we may be subject to our decision being reversed on appeal. So this is something that obviously I take very seriously, but it is a constitutional obligation that we have. So I would just reiterate the public trust, and I'm sure Jonathan's public trust video is very helpful, but I think that that's something that we as commissioners, when we have matters that come before us, whether they're an SUP, a DBA, I think this obligation is required for all of our actions. Mahalo.
Thank you, Commissioner Chang.
Mr. Chair, at this point, I suggest that we take a break.
And when we come back, do you have more to present?
When we come back, we'll have a presentation by the Office of Planning and Sustainable Development.
So before we go there, Mr. Derrickson, can you observe anyone in the audience that wishes to provide additional public testimony on the training?
Yes, Chair, I think we have one attendee who has raised their hand because they've priorly let the staff know that they wanted to present public testimony today. So that's Mr. Church, and I can facilitate by, if you agree, I'll put him, promote him to panelist.
Yeah, let's invite Mr. Church to provide his public testimony at this point in time, and then we'll take a break.
Okay, will do. Okay, it's in the process of, he's in the process of coming on.
Mr. Church, I see your name. Please let us know when you can activate your audio and or video.
Chair, I've asked him to unmute. As it occurred yesterday, it takes him a little while, I think, to get it to connect.
There we go.
I tried again.
No, we hear you now, Mr. Church. Please state your name and address for the record one more time.
My name is Ken Church. I live on the Big Island in the area of Hakalau.
And please provide you have 2 minutes for additional public testimony. Please proceed.
It's a big problem that the LUC's administrative office does not always comply with deadlines that are specified in HAR, yet specified deadlines for petitioner's performance is vigorously enforced. I have maybe 5 points here. That's point one. Point 2, yesterday's hearing began with Ms. Chang describing how public testimony should be managed under the new law. And she said at the end of each day, the public should testify. So here we are today, dealing with yesterday as well as today. The administrative office, another point, the administrative office abuses its authority by not accepting petitions as complete when they are indeed complete. That blocks the 180-day deadline, and sometimes no matter what one does, they can't meet the standard that their administrative office applies. Boundary interpretations are a big problem. We talked about it a little bit today. The LUC's rules should require the LUC shall consider other LUC records when requested to do so by a petitioner. Your current rule says may. The hearing should be fact-based. Ours was not. In our case, we were required to correct a boundary on a neighboring property.
Mr. Church, if I can, I'd like you to confine your testimony to the training that we've observed, not to your particular case.
Well, you just heard about boundary interpretations.
Generic.
And my point is that it's improper to force a petitioner to correct a boundary that doesn't exist on their property. And that's what's happened to us. Another point. You also talked about staff. No, I also raised the issue of staff memorandums that are given to petition or commissioners before a hearing. Those should always be given to a petitioner also, in order that if there are errors in it, it may be corrected in the petitioner's rebuttals. That happened also in ours. Preponderance of evidence and burden of persuasion come from 9110.5, and it's cited 9110 is for contested case hearings. So the commission has to rely solely on the evidence. Discretion is not provided for in the rules, and cross-examination of witnesses should be applied if you're going to apply 9110.5 as a standard.
Mr. Church, could you please summarize your testimony?
I have one paragraph left. Mr. Orodanker stated that decisions and orders must be based on what is presented to the commissioners. That is not always done, and sometimes declaratory orders cite evidence that was never presented during the hearing. That's all my comments.
Thank you very much for your testimony. Commissioners, do you have any questions for Mr. Church? I cannot see, Mr. Derrickson, if there is any commissioners raising their hand. Can you let me know if anybody would like to, has any questions?
No, there's none of the commissioners are raising their hands.
Okay, thank you, Mr. Church. Are there any other members of the public that wish to testify at this time, Mr. Derrickson?
None of the other attendees. Sorry, none of the other attendees are raising their hand to testify.
Okay, thank you. It's 10:58. We're going to take a break, 10-minute break, and we'll resume with a presentation by the Office of Planning and Sustainable Development. I'll see you all at 11:08. Thank you. We'll go back on the record now. This is Chair Giovanni speaking. So now we will be inviting a presentation from the Office of Planning and Sustainable Development. Understanding is that Attorney General Brian Yee will make a presentation on the roles and relationships within the office, in particular the Land Use Division, the Coastal Zone Management Program, the GIS Program, and the Environmental Review Program. Following that, we'll take a lunch break and then resume after lunch with a further presentation by the State Sustainability Coordinator, Danielle Bass, who will inform us about the statewide sustainability program. So at this time, I'd like to invite Mr. Yee to take command of the mic and have his presentation.
Mr. Chair,
I can't hear you, Mr. Orendanker.
Mr. Chair, we have
Problem with the audio. Cannot understand what you're saying. Mr. Orendanker, are you there? Can you hear me?
Hello?
Yes, that's better.
Okay. To repeat, we have the Director of the Office of Planning and Sustainable Development, Mary Alice Evans here, who will begin the presentation. And take it from there. Thank you.
Thank you. Ms. Evans, would you please begin? And welcome to the Land Use Commission today.
Thank you, Chair Giovanni and members. Can you hear me? Is my sound okay? Sound check.
Yeah, very good. Thank you.
Thank you. First of all, thank you so much for inviting us to come and share with you some of the broader elements of the Office of Planning and Sustainable Development. We are very happy to be here today. Next slide. I wanted to give you a quick overview of some of the statutes that we look at and I know impact your work. And there is an important omission, and that is Chapter 174C, the State Water Code. And I had intended to put that on there. And as you can see, land use planning and state planning have an impressive amount of statutory code that we all have to look at and see how they interact. Next slide, please. Chapter 225M lays out the responsibilities of the Office of Planning and Sustainable Development. And we have 10 responsibilities, and I just want to quickly run through them. And some of them have been there since the beginning when the office was created in 1986 as the Office of State Planning and have continued. We've significantly downsized in staff and capacity since that initial office in 1986 and 87, which was in the governor's office. So some things we don't have the staff to do on a regular basis. But next slide. As you can see, there's some additions: climate adaptation planning, smart growth and transit-oriented development, and an environmental review program. Those are recent additions to the Office of Planning and Sustainable Development, and you will be hearing from the transit-oriented development team and the environmental review team later. Next slide. These are official programs that are part of the Office of Planning and Sustainable Development. The Coastal Zone Management Program, which is governed by Chapter 205A, the Environmental Review Program, which is the former Office of Environmental Quality Control, which was created in the Department of Health, and then the legislature transferred it over to the Office of Planning and Sustainable Development in the regular session of 2021. The Land Use Commission, the Land Use Division, Special Plans Branch, Transit-Oriented Development was created by the legislature, and also the State Geographic Information System and the Statewide Sustainability Program. Next slide. A few notes on boards. The Marine and Coastal Zone Advocacy Council advises our Coastal Zone Management Program. It's a very active council. They look at protection of fisheries, coastal zones, the Muliwai between Mauka and Makai, and they provide, they're statewide. They're representatives from all of the islands. The Environmental Advisory Council That came over with the Office of Environmental Quality Control. They also are a statewide body. They meet monthly and they look at how to, they look at the policies that the Chapter 343 charges the state with. The Land Use Commission, I want to note that the Land Use Commission, both staff and the commission, have a policy firewall between the administration of the Office of Planning and Sustainable Development. That's provided in the law so that all of your work is you're an autonomous body, and our office does not, other than our areas where we are a party to your proceedings, we don't attempt to make decisions for you and for your staff. We have both a policy firewall in statute and a fiscal firewall in a memorandum of agreement that Dan Ordenker and I have executed. That's to protect the public's understanding of your proceedings as being autonomous and transparent. The statewide Comprehensive Economic Development Strategy Committee, every 5 years, the state conducts a comprehensive economic development strategy for the purpose of making state and county agencies and nonprofits eligible to apply for economic development funds from the federal government. We're in that process right now. We have a statewide committee that's been talking about what kinds of strengths, weaknesses, opportunities, and threats are involved in keeping a healthy, sustainable economy for the state of Hawaii. The State Transit-Oriented Development Council, I co-chair that with Denise Iseri Matsubara, who is the executive director of the Hawaii Housing Finance and Development Corporation. That focus, legislators wanted us to look at ways to increase housing density and create mixed-use communities on transit corridors and the rail line. That's all in the urban districts, so I don't think any of that will come before this board, but it is a very active group. We normally have about 50 people on every meeting, and the legislature has been kind enough to give us some resources to do planning studies in all 4 counties around transit corridors. The Hawaii Board of Geographic Names, very quiet, small board, but it actually has executive authority to decide on the names of geographic features within the state. So they talk to members of the community around that, a new feature such as Fissure 8 on the Big Island. And they take testimony from lineal descendants, from Hawaiian experts, and they make a decision on a name, and then that goes to the U.S. Board of Geographic Names and on all maps. The Greenhouse Gas Sequestration Task Force, that's a permanent body charged with reducing carbon emissions on natural and working lands, and that we have a report due to the legislature for the 2023 session. And then the Hawaii Climate Change Mitigation and Adaptation Commission, the Office of Planning's director co-chairs that with the Land Board's chair. And that's also an extremely active group as we look at the issues of sea level rise, heat stress, carbon emission reductions, and adaptations to have Hawaii more resilient in the face of increasing climate volatility. So with that, I'd like to turn the next briefing over to Arthur Buto, who is the head of our statewide geographic information system. I believe he's joining us on Zoom.
Thank you, Evans. Buto, will you take the mic?
Morning, Chair, Commissioners. My name is Arthur Buto. As Mary Alice said, I'm the manager of the statewide GIS program. And my apologies if you're already familiar with the term, but I'd like to start by defining GIS. GIS stands for Geographic Information System, and it is sort of that whole ball of wax of an information system. So at its core, it's data, but it includes methods to collect that data, input that data. Things that you may be familiar with are things like GPS in your phones or on more sophisticated devices to collect location information. It's the visualization system of that data. Typically, you'll see it in a map, whether it's an online map or a printed map, a hard copy map, and as well analysis applications. So ways to take all that data and perform some kind of analysis on it. That's all part of a GIS. And some familiar things that you see every day are things like weather maps, traffic flow maps. You're probably familiar with Google Maps. Yelp uses a GIS in the background. And then the COVID dashboard more recently, and the Red Hill maps as well. So all that is using data that has some kind of spatial or location relevant information in it, data in it, and using it to visualize or represent that data in a more user-friendly way. And among the benefits of the GIS is that it can take multiple sets of data in a particular geographic frame that may be related to each other, or a relationship may reveal itself by appearing together in on a map. And technology is a big part of the GIS to perform that analysis. Having said that, GIS is not an authoritative set of data. It's the boundaries that you'll see in GIS are not surveyed boundaries. As Dan O alluded to, a lot of these data are old or historical, or parts of those data are old, and they may have been developed in 60s or 70s, various ways, tracing lines on, literally tracing lines on a map or a photo. So as technology has gotten better, as data collection has gotten better, some of those boundaries may appear a little bit out of whack. So it's not, GIS is not a system of legal data. It's not to be used in that way. And again, getting back to the boundary interpretation, we do have the state land use district layer in our GIS data set. But again, it's not authoritative, and any questions, it's used as a planning tool and as a broad visualization tool, but any questions or concerns about specific items, those are interpreted by, or those are analyzed by the Land Use Commission staff. So with that, I am gonna move on to the slide. So by statute, we're in, sorry, didn't want to advance the slide. Sorry, Dan. We're in 225M, the statute, and in there we are tasked with coordinating GIS efforts among state, county, and federal agencies. We maintain a geodatabase of over 400 layers. Included in there is a state land use district boundary layer. And we provide a way for agencies to share data, either internally within other agencies or with other agencies, or with the general public. And those 400 plus data sets, almost all of them are being shared with the general public through our GeoPortal. And in addition, we do develop some applications for agencies and the general public. So one of the ones that we have is a state land use district locator app. And that's, again, a visualization or a map-based interface that shows the land use district boundaries and allows you to search by TMK or by street address to see where you may lie. And again, it's not a legal interpretation, but it does give you a general idea within the accuracy of those boundaries and of the parcel boundaries as well, because those will vary. But it gives you an idea of just generally where you may be in relation to the state land use district boundaries. We also respond to requests for maps and data from state agencies and the legislature. We're a resource for other agencies consulting on GIS projects or projects that may involve GIS. And more recently, in the last within the last 10 years, the state has had an enterprise agreement with Esri, one of the global leaders in GIS solutions. We have an enterprise license agreement with them, so it allows any state employee to have a license for the desktop software as well. We can provide accounts in the online mapping platform. And Land Use Commission staff, I think Fred and Scott both have accounts, and I think they both have licenses for the software. So we're there to support them in their use of the platform as well. And that's about it. Thank you.
Thank you, Mr. Butow. Ms. Evans, where do we go next?
Thank you, Chair. The next presenter will be Justine Nihipali, the Planning Program Manager for the Coastal Zone Management Program.
Terrific. Let's proceed.
Thank you, Chair. Sound check, everything okay? Okay, I will take that. You muted, so I'll take that as a yes.
Yes.
Okay, great. Thank you. Good morning, Chair and Commissioners. Thank you for the opportunity to appear before you this morning. My name is Justine Nihipali. I am the Planning Program Manager here with the Coastal Zone Management Program. We're housed, as you know, in the Office of Planning and Sustainable Development in the Planning Division. Next slide, Erin. I just wanted to share just kind of a broad overview of how we came to be. The National Coastal Zone Management Act was passed in 1972, which recognized the increasing growth pressures on coastal zone and the need to balance that with the environment. In Hawaii, the CZM program was established by the state in 1977 and approved in 1978 by the National Oceanic and Atmospheric Association, and were supported by the Office for Coastal Management. We're one of 34 states and territories with an approved program across the nation. The program itself is a voluntary partnership between the state and the federal agency, and establishes what's called a cooperative agreement between the two entities. And the purpose of which is to provide for the effective management, beneficial use, protection, and development of the coastal zone. As the slide notes, there were two major incentives for the state to establish a program. The first is to receive federal funding from the national, from NOAA to support the program, as well as the privilege of administering what is called federal consistency, where certain federal actions must be in compliance with state authorities in the coastal zone. Next slide, please. The Hawaii Coastal Zone Management Program, I'm going to show a brief video, hopefully it'll pop up, about what CZM is within the state. And if it doesn't play, that's okay, Erin. Okay, yeah, I think we're having some, maybe the link didn't go through. The statutory authority for the CZM program is within HRS 205A, which is in 4 parts. If we could bring that slide up, Erin, that'd be great. Part 1 is the objectives and policies for the CZM program. Part 2 is the special management area permitting system. Let's see. Move forward. Sorry, I don't want to lose anyone because there are notes there on the slide. Thank you. Part 3 is the shoreline setbacks. So the distance between the established shoreline and how the county derives the siting of new development, as well as part 4, marine and coastal affairs, which establishes the ocean resources management plan and our responsibilities as the coastal zone management program to lead the implementation and coordination of the ocean resources management plan. We also administer with Department of Health, the Coastal Non-Point Pollution Control Program, which is a requirement by NOAA and EPA and jointly administered at the federal level by those two entities. Next slide. So what do we mean by the coastal zone? The coastal zone actually encompasses the entirety of the state from Mauka to Mackay out to 3 nautical miles. The structure of the program itself was established as what is called a network program, which utilized the laws and functions of existing agencies in the state and the counties. Actions cross multiple jurisdictions along the way, from the ridgeline to agriculture, conservation, and urban lands, our beaches, as well as nearshore waters. The Hawaii legislature designed the cesium law to create a program that crosses many of these boundaries. And each county also participates in the program. And together with all the state agencies, they must assure that their statutes, ordinance, rules, and actions comply with the cesium objectives and policies in HRS 205 Part 1. So where does the Land Use Commission fit in? Next slide, Erin. As an example, and this is a little hard to see, these are the agencies with statutory authority and administrative rules that uphold the objectives of cesium law. Within the scope of its authority, the Land Use Commission is one of many entities that, in combination with other agencies such as DLNR and county authorities, carries out a portion of cesium objectives and policies related to providing coastal recreational, excuse me, I'm just getting over a cold, opportunities accessible to the public. And we do thank the commission and the commission staff for its role to implement cesium law within its authorities. Next slide, please. I just wanted to provide some additional resources in your spare time, as you all know. The first link, I believe you guys have this presentation, is to the National Coastal Zone Management Program. We've also created a resource called the Authorities Matrix, which identifies each of the agencies and its governing laws and administrative rules that help to implement the 10 objectives and policies of cesium law. There's further information relating to special management area permitting system, which the county are authorities for the planning commissions, with the exception of City and County of Honolulu, whose city council is the authority for determining and issuing the permits with support from the planning departments. We provide support and technical assistance to the planning departments through the support of 14 employees in the planning departments for Kauai, Hawaii, and Maui counties. And we are working with the Department of Planning and Permitting to reestablish support for positions there if funding does increase over time. County profiles, it's a link to how, for you to learn how cesium funding has or is being utilized within your county. We have established projects with those counties to address some of their priority concerns relating to coastal zone management and balanced use of resources in their state. And then I have a link also to the Hawaii Ocean Resources Management Plan, which by statute state agencies with support from federal agencies as partners and county are tasked with participating in implementation of the plan to address issues that may not be adequately addressed by existing policies and functions. And we are tasked with coordinating around those issues to try to address that with CZM funding and CZM staff resources. We work on these initiatives with agencies that do manage the natural resources in the state. We work, and then we have another additional resource that highlights a number of the recent projects and current projects that we're working on, including documenting and working with the University of Hawaii to provide technical resources to inform decision-making related to shoreline setbacks and siting of new development with Dr. Chip Fletcher and his team. We are also working on an initiative set forth by Act 178 of 2021, which addresses sea level rise impacts and state facilities and developing adaptation strategies and prioritization for adaptation within the state. We're also leading discussions and implementation to coordinate efforts between agencies such as DLNR and the county planning departments and technical experts to address shoreline management issues such as coastal erosion and sea level rise impacts. As part of that, assessing this strategy or adaptation option of managed retreat by looking at legal and policy implications as it relates to existing policies and land use issues. We're also working on projects with HIEMA and the Building Code Council to strengthen building codes for resilience to tsunami hazards, to inform future siting, as well as stronger building codes for essential facilities within the state. We also work to develop guidance to address the reduction of non-point source pollution within the environmental review process, as well as decision-making from county and state reviewers. And then we're also collaborating with DLNR DAR to strengthen its ability to work with communities to inform nearshore fisheries management and regulations. So as you know, the Coastal Zone Management Program has a vast authority, and we do work with as many agencies as possible to address some of these current issues that have been identified in the Ocean Resources Management Plan, as well as the requirements that we have to provide technical oversight over SMA and facilitating the administration of the Federal Consistency Program. With that, I'm going to conclude my presentation because I know that we have a number of people to hear from today. Thank you.
Thank you very much. Mr. Erickson, can you advise if any of the commissioners have any questions or comments on what they've already heard from OPSD?
None of the commissioners at this point want to ask any questions. I will let you know if any hands go up.
Okay, great. So I have a quick question for Ms. Niipali. I've been reading and following the fact that traditional fish ponds are coming back with an abundance around the state. Is there a role that your program plays in that process?
There are a few roles that our office plays. The first is for federal consistency. We worked with the Army Corps and the Department of Health for the Clean Water Act to address actions within the water for permitting purposes. The second is something that we aspire to do, but we haven't embarked on that initiative just yet, is to better understand how cultural resources do serve as, in some cases, ways to protect shoreline areas. We do have an initiative that we are looking to embark on, that we want to ensure that any climate adaptation policy that is developed by our state addresses cultural resources, particularly along the shoreline, not to exclude heiau, other pohaku and cultural resources. We've had some preliminary discussions with scholars at the university about how to even frame and approach that, since this is not something that we would feel as comfortable leading. We would want to support and have community entities be the ones that helped define how that would occur. But yes, traditional resources, I think, particularly fish ponds, would serve as that balanced perspective relating to food sustainability, strengthening cultural communities, as well as in some cases act as protection against coastal erosion. But I do know that a lot of these community practitioners do need a lot of assistance because they're small nonprofits and often families who are managing those efforts. So we don't have direct projects right now.
Great, thank you for the commentary. So Ms. Evans, I'll turn it back to you for continuation.
So next up is Ruby Edwards. Ruby.
Thank you. Good morning, Chair Giovanni and Commissioners. My name is Ruby Edwards. I'm a senior planner with the Land Use Division and the acting TOD Planning Program Manager within the Land Use Division. We also have a TOD Council Coordinator who staffs this new program, which was established, which Mary Alice mentioned earlier, was established in 2016 to really facilitate statewide TOD planning, especially around state lands. And this was all instigated primarily by the rail development along the Honolulu Rail Corridor. So the Act 130 established both the Hawaii Interagency Council for Transit-Oriented Development. It's that forum to advise state and county agencies and to coordinate around statewide TOD planning efforts. And the Act also designated OPSD as the lead state agency for smart growth and TOD, amending 225M and its responsibilities there. Next slide. Very briefly, the council, the TOD Council is a 25-member advisory council made up of state and county agencies, legislator reps, and non-agency reps from the community, as well as an ex officio member from HUD. They have been responsible for approving a state transit-oriented strategic plan for transit-oriented development last issued in 2018. And of that plan, there are about 65 plus TOD projects that were identified to pursue by state and county agencies, and this council meets to discuss some of those projects and how to promote TOD statewide. Next slide. Real quickly, what is TOD? It's really basically a smart growth tool that really looks at improving urban communities. So we're using it as a means to look at increased mixed income and affordable housing stock, preserving and conserving agricultural lands and our rural open spaces, trying to improve the livability of communities, reducing vehicle miles traveled and associated greenhouse gas emissions, and managing the cost of urban infrastructure. Next slide, Erin. And what exactly is TOD? It's really basically a compact walkable development centered around and integrated with transit, generally a walking distance or walkable distance of 1/4 to half a mile from a transit station or transit node. And the defining elements really are fairly straightforward. A lot of transit, transit-rich areas, higher density, a mix of uses with commercial and civic anchors uses, as well as residential, integrated in a compact area, a very strong pedestrian orientation, and a lot of connectivity, preferably around a grid that allows for people to have multiple means of being able to move within a neighborhood, and multimodal transportation options that is giving a lot of mobility options to residents. So the sum of this really is looking at creating a dynamic live, work, play community, a whole community that really promotes a shift from individual auto use and reliance on autos to for our daily activities. Next slide, Erin. So what does TOD look like? through the TOD Council, OPSD and its state and county agencies will work very closely with the counties to try to identify what's the TOD potential across the state and how do we achieve that potential. On Oahu, of course, we're talking about housing and mixed-use communities at stations along the Honolulu Rail Corridor. On the neighbor islands, we're looking at housing and mixed-use communities at bus transit centers and hubs of a smaller scale, lower scale, and lower density than it, of course, on the urban core in Oahu. Next slide, Erin. So what does this mean for you? Not really that much, because of course, most of the areas that we're working in are really already within the urban land use district and are already urbanized. So we're really focusing on urban infill and really looking at how to improve the urban communities that have already been entitled and are already in place. Next slide, Erin. But if we were to try and leave you with anything, it's really looking at what does that land use decision-making look like through a smart growth or TOD lens? And really it's asking the questions of, does a proposal support or contribute to a development pattern that is compact, it's dense, is it walkable and pedestrian oriented? Does it promote transit ridership and transit use? Is it going to be transit rich? Does it incorporate many mobility options, walking, cycling, rolling? Does it promote mixed income housing and create vibrant mixed use livable workplace communities that our residents can enjoy? And I turn it over to the next person. Thank you.
Thank you. Next person.
Chair, this is Gary Okuda. May I ask a question?
Please do, Commissioner Okuda.
Yeah, thank you very much for your presentation. To put you on the hot seat, in your view as a planner, does this mean that if we want to really increase housing stock to provide housing for local people to the extent the law requires or allows, what we really have to look for is more dense development in the urban core, and really that's more effective in delivering housing to the people of Hawaii versus redesignating agriculture to urban. I mean, go ahead, I'm sorry.
From a professional planning perspective, with the mission of smart growth and having to balance growth with agricultural feasibility and viability and the protection of rural and natural lands, I would have to say yes, that we're an island community, limited land area, and that our best option for providing housing is to do so in our urban areas with higher density. That's going to provide more units. There are costs to that though. The building costs, as you go higher, the building costs go up. So it's not easy. And sometimes the infrastructure is insufficient to support that kind of density. But ultimately, we're going to get more housing units if we really are able to do more infill redevelopment into higher density areas.
Okay, and as a short follow-up question, based on your knowledge and experience as a professional planner, do you believe that if one of the goals is to deliver housing units more quickly and in larger numbers, even taking all the infrastructure issues that you face in an urban area, but also considering the infrastructure you have to build out in agricultural areas, that it's probably faster and maybe more efficient to some extent to do infill development, build more denser or with more density in the urban area, because that is probably the more efficient or faster way of delivering housing for locals on Oahu anyway.
Well, certainly, if you do urban infill residential development, you're going to lop off a lot of that entitlement time of, reclassifying and rezoning, changing land use designations. You're going to lop off that front end that delays and adds cost to the development process. Yes.
Okay, so the final question is this. So if we got to make some hard choices, maybe the hard choice we have to make as a community is we have to be willing to live with higher density in the urban core if we really want to deliver housing for our local residents. Would that be a fair statement?
That would be a fair statement.
Okay, thank you very much. Thank you for your testimony and explanation.
I would also add to that, Commissioner Okuda, that there's a correlating effect on traffic issues with that approach as well, which could be beneficial. Okay, next presenter, I presume.
The next presenter is Tom Eisen.
Please proceed, Mr. Eisen.
Hey, hello, I take it you can hear me?
Yes, all good.
Yeah, I'm Tom Eisen, a planner with the environmental review process. And I know we're running late, so I'll go through this as quickly as we can. But the Hawaii's environmental review process is established and codified in HRS Chapter 343. It's been in existence since the 70s. It was modeled in general after the federal environmental review process, which goes by the acronym NEPA for the National Environmental Policy Act. So even though Chapter 333 is not called it's not titled the Hawaii Environmental Policy Act, the process often goes by HEPA as an acronym. So expect to hear that from time to time. Next slide, please. Okay, at the present, we are minimally staffed. I'm the planner, and there's two others in the office with me. My primary responsibility is to produce and publish the environmental notice, which you may know is a bulletin that's put out twice each month, advertising the availability of environmental documents that have been submitted in various points along the process line, draft EAs, final EAs, EISs, things like that. I maintain an online database of all the EAs and EISs and other environmental documents, so they can be searched and found online. And then in general, provide guidance and support to all the stakeholders in the process. I'll get into that a little bit later. We have another specialist, Les Segundo. He is primarily responsible for providing staff support to the Environmental Advisory Council that our director mentioned, came over with us when we moved to OPSD last year. So it's a volunteer appointed body, but he's the one member who has staffing for them. And he also provides guidance and support to the different stakeholders in the process. And then we have a secretary who provides a lot of great administrative support to the program. Next slide, please. Okay, I won't read this, but here's some statutory language that reinforces the idea that balance is key to the process. So pretty much whenever we're doing everything, balance, balance, balance. Next slide, please. Okay, here's some guiding principles. I'll run through them pretty quickly. Probably the first and foremost is the realization that the process is a disclosure process. It is not a permitting process. It exists to provide some vetted objective information to decision makers before it gets into the permitting process. Proposed action must hit a trigger for HEPA to apply. So there's many actions that HEPA does not apply to and don't have to do in EA or EIS. We're constantly being asked, why didn't this project require an EA or that one? And the triggers are in the next slide. I'll go through that. As far as the Land Use Commission in particular, you guys issued discretionary consents, and so that makes you an approving agency under HEPA. And as an approving agency, you have the authority to make all the necessary determinations for any action that is going through you. So the authority lies with you. A lot of people think we have authority. Our office, we have very, very little authority over any given project going through. It's always the approving agency or a proposing agency that gets to make all the determinations and get sued if somebody doesn't like those determinations. The whole notion of significance is pretty important in various stages of the process. There are significance criteria in the rules. I'll refer you to the rules if you want to go through them, but determining the appropriate level of review is something need an EIS or does it need an EA? It's whether it is a significant impact is likely. So that's an important concept to keep in mind. There are 3 general levels of environmental review. Exemption, which they're exempted from the erstwhile requirement to prepare an EA or an EA, or if there's a likelihood of significant impact, then the full-blown environmental impact statement would be required. So if significance is not anticipated, then exemption is likely the appropriate process. If an agency feels that they can just say right off the bat that there will not be a significant impact, they're potentially able to exempt it from the requirement to prepare an EA. If they do anticipate a significant impact, then it would go direct to the EIS. And so it's basically the situations where an agency is unsure if it's significant or not, that an environmental assessment is prepared, and it's prepared just to be able to make that determination of significance or not. There's basically 2 outcomes. The last point, you'd make you'd issue a finding of no significant impact, or you would say that an EIS is required and then ultimately accepted. That's the determination at the end of the EIS process. There's a lot of public comments involved in our process, similar to yours. So that's just part of the situation. And a final EA or EIS must include an adequate response to all substantive comments submitted. That's a big point in the review process. Next slide. Okay, these are the triggers. I won't go through them all. I highlighted number 7, so any reclassification of land classified as conservation district, that is a trigger for the HEPA process. So it would require presumably an EA, maybe an EIS, could be exempted, but it is a trigger. The other triggers are listed here. It's probably unlikely that any of those would come to you. The most common trigger across the board is the first one, the use of state or county lands or funds. So basically anything that any agency does, state or county, hits trigger 1. So a whole lot of actions that are proposed by agencies go through this process. But there are other sensitive areas that the legislature has decided become a trigger. Next slide, please. Okay, again, a lot of what we do is provide guidance to the various stakeholders, whether they're agencies, applicants, consultants, members of the general public, special interest groups. So we encourage everyone to contact us and we try to provide them guidance. We can't always answer their questions. We help them noodle through problems and try to make their own decision. Again, we don't have the authority. We can't say what is right, what is not right or anything. We just provide support and guidance, and we provide it to your staff, and we're available and online in a lot of ways. So I'll wrap up my presentation now. Thank you.
Thank you. If there are no other questions, I'd like to introduce myself. My name is Brian Yee. I'm a Deputy Attorney General with the Attorney General's Office. I have been appearing in front of the Land Use Commission for a number of years, although there is a position available to be devoted to OPSD, which is currently vacant. So if anyone knows a bright attorney who's intellectually curious and loves land use law, please have them call me. The OPSD had promised me 30 minutes. They lied. And I know I am the only thing standing between you and lunch. So I'm going to do my best to kind of rush through this. But regardless of the amount of time, I do want to take a moment, because you probably did this yesterday, but I want to be able to just say, especially to the new commissioners, thank you and welcome. You're going to spend more work to do for less pay than you may do for anything else. But I'm really hoping it'll be very satisfying, because it has been for me. And because of your service, you're really making a difference in the future of this state. So thank you.
Mr. Yee, this is the chair. I want to encourage you to take the time you need today to make your points and not overly rush through it. You always provide commentary of value to this commission, and it's very much appreciated.
Thank you very much, Chair. Next slide. I'm going to go over three things. The first are just what's the role of OPSD in your dockets. You'll be dealing with the land use division from OPSD most often. The second would be the types of matters. This was discussed by Scott Derrickson, but I'll be talking about what OP does on each of these matters. And then the third will be some of the major issues. There are a lot of issues, but I'm going to pick a few of them just to highlight initially for today. Next slide. OPSD's role primarily does two things. One, it provides informed analysis, and second, it provides your recommendations. So it's important because we are able to provide you with information. We can provide you with state witnesses, documents, and not really well discussed a lot, we also cross-examine the petitioner's witnesses. So they have a lot of information, but it's also important to sometimes to draw out some of the entire picture from the witnesses, not just one side. In addition to the information, we provide you with the analysis of what is this, why is this information important? How does it affect your decision? I don't know how they teach math now, but back in the day, you were always required to show your work. And that's what's probably more important for you than anything else that we do, is we explain to you why we think the information is important, how does it affect your decision, and we show you that analysis for your ultimate decision. But at least you can see how we applied it. And then, of course, we provide you with a recommendation. So you can agree, you can disagree, you do disagree, and that's perfectly fine. But is at least a viewpoint that you'll be able to have, that you have what our recommendation would be. By the way, I'm going fairly quickly, but let me just take a moment to say, if at any time during the presentation you have a question or a comment, just feel free to ask. The presentation is often most interesting based on those questions or comments, so feel free to do so. Next slide. I should mention three things, by the way, about OPSD's role. One is OPSD provides you with a relatively neutral position. So we're not going to benefit or disbenefit from whether the land is or isn't reclassified. So it gives you just sort of a neutral position on it. Second, you get a unified position from all state agencies, and there are a lot of state agencies. So we give you one unified presentation on that state position. And sometimes that requires some effort on our part to make sure it's all unified, but that's one of the things we do. And finally, we give you the analysis on an individual case, considering the larger context, right? Because the petitioner is really concerned about their parcel. But we appear in front of you on all of the district boundary amendment cases and special permits, et cetera. So we're aware of how this applies to other cases, and we want to make sure you are also aware of that as well. So we will try to bring before you how it fits into the larger context as best we can. Sorry. Moving on. These are some of the tasks that we do. In district boundary amendments, we are a mandated party. You may not want to see us, but you're going to see us anyway because you have to. It's like seatbelts, it's the law. So we are going to appear in every single one of these district boundary amendment petitions. And then these are some of the tasks. I won't go through all of these things individually. Let me just highlight a couple of them. One of the things is we discuss the issues with the petitioner throughout the process. And that means before the petition is filed, we'll meet with them and we'll try to talk it over with them about what are you proposing? What are the problems you anticipate? What are the problems we anticipate? What are the additional facts we think you're going to need to draw out? Very preliminary, of course. And we're going to continue that discussion throughout the process. So when they file their EA, we may have a discussion. For the hearing, we may have a discussion. During the hearing, we may have a discussion. And I think that is intended to do a few things. One is to make your job easier so that you can get some of these issues narrowed and if we can focus. And because we may or may not agree with the petitioner on all things, and that's perfectly fine. Petitioners are allowed to have their point of view. We're not saying we're always right. But at least we can find out what are the issues, why are we disagreeing? We also want to make sure we tell the petitioner. We don't want to surprise the petitioner. We want them to know what our concerns would be and for them to tell us why they disagree. As I said, if we're wrong, we want to know, and we would much prefer to be able to have that process with them without going through sort of a really long hearing until we ultimately conclude, oh, I'm sorry, we're wrong, they're right. So we want to have that discussion without having to involve your precious time. And of course, it streamlines the process. There's always criticism about state processes and how it could be streamlined and made shorter and made faster. To some extent, some of it is built into the process. You need time to consider. You need time to get all the evidence. But to the extent we can, narrow the issues and not take so much time in the hearing, we want to do that. And so we talk with the petitioner to try to do that. We also solicit comments from a large number of agencies. It takes a lot of time. It's one of those, ducks plus on a pond. Those feet are paddling furiously beneath the water. We work really hard. And as you can imagine, testifying in front of the Land Use Commission is on no one's top 10 list of things to do. But we go and we convince them why it's important. And it is important. It's important that you hear from some of these state agencies. But, sometimes it takes a little bit of effort. But we make the effort and we're generally successful at it. It also takes some time. So just to acknowledge now that sometimes we would like to get you things faster. It sometimes takes us a while to get all the information. I'm not going to name names, but I think everyone in the development community knows how long it takes to get stuff from state agencies sometimes. We try to help so that it doesn't delay this process. We do our best. Next slide.
Mr. Yee, question.
Yes.
When you talk about your interactions with the petitioner, that often results in your recommendation of conditions to be included in our order, which are quote unquote amenable to the petitioner itself. Can you speak to how that process works? Because I think that to be of great value.
Yes. So on all matters, not just district boundary amendments, but particularly district boundary amendments, the Office of Planning and Sustainable Development may agree that the land should be reclassified, but would be concerned about some of the impacts from the project. So we want to impose conditions which would minimize those impacts. And so we based upon the information we get from the other state agencies, we then create a set of proposed conditions, and we try to send that to the petitioner ahead of time. So before we send it to you, we send it to the petitioner and get their feedback. Sometimes they agree, sometimes they're persuaded, sometimes they're not. To the extent we can get that agreement, so much faster. To present, we still present you with a factual basis, but it does make the process much faster than when we are going to be in disagreement and when we know we have to give you a really iron tight, case on why something needs to be done. So, why this particular traffic mitigation is required in this case, because it's really important. And we will have conflicting experts, et cetera, et cetera.
Thank you.
Okay.
Mr. Chair, can I ask Mr. Yee raise a question?
Please.
I, like Yeah, I like the chair. I really appreciate you being here, and please take the time. Quite frankly, I think this is a really important component for our training. One of the questions I have is, you helped to coordinate and get comments from state agencies. And I have found that many instances, comments from the Department of Transportation, Department of Land and Natural Resources, with respect to especially protection of endangered plant species, and State Historic Preservation Division impacts historic resources. I mean, in my mind, those are really critical kinds of timely responses that LUC needs. And we always don't get that. And I know you guys are doing the best that you can, but sometimes I feel like we are at a disadvantage by not getting those responses. So, what is the process that you go through, and what kind of recommendations do you make when we do not get timely responses from those agencies?
So in the district boundary amendment, which is probably the most extensive amount of work that we do among the types of matters, when the petition is complete and there's a determination made by the LUC that yes, this petition is now complete, copies of the petition are sent to a large number of agencies, including DOT and various parts of DLNR, actually all of DNR, and then it goes to a number of different agencies within DLNR. We then give them a deadline to reply. We then call them after the deadline is passed. And then we talk to certain individuals in those agencies, sometimes multiple people, if we don't get a response. And I mean, some of the problems, some of these agencies particularly, right? Some agencies are more pressed than others. We sometimes do not get the response that we need because some of the agencies you mentioned have very substantive information to provide. It's not a yes or no. It's not a checkbox. It's an actual analysis of the EIS and the expert testimony and what they said to determine, oh, yes, we have looked at the traffic impact analysis report. There are 8 problems, 8 concerns we have, and they are detailed out. They can be as detailed as the estimated number of people leaving from the project in the morning is too low. What is this based on? Because the prior project, located 15 miles away, which seems to be similar than yours, has a much higher number. And so, and it will be that level of analysis and review of the TIR that is done. Others are simply just really busy. And we have those challenges. That is a larger problem that OPSD cannot solve. We can only try to help mitigate for LUC.
So just a follow-up question. So when those particular agencies do not respond, in those instances, do you include as a proposed condition, subject to the applicant consulting and getting concurrence from, DOT or DLNR or SHPD in particular, because it really could make a difference on the project by their responses.
Probably the more likely thing we do is we submit amended conditions. So we submit late conditions, which is another problem, right? Because we're trying to make sure the petitioner sees it, petitioner is aware of the issue. We might call the petitioner and say we don't have any comments from, but we are less likely to submit to you conditions which don't have a factual basis.
Just my final comment. I know that you mentioned that there's a lot of discussions that your office has with the petitioner. Do you also encourage the petitioner to confer with these agencies in advance so that it's on their radar and that they may provide more timely responses?
Yes and no. to a certain extent, the petitioners need to be ready before they talk with the agencies. So if you don't have a TIAR, your discussions with the Department of Transportation are pretty limited because they really want to see that analysis. But certainly after they finished it, they should. I mean, we got a motion to amend recently where, they have not talked to the state agencies at all. And in that particular motion to amend, a little different because we're not aware of motions to amend. The district boundary amendments have, you file the complaint and it's a long time before you get to the hearing. On a motion to amend, until you file that motion to amend, we often don't know. Sometimes they'll call ahead of time, but some people give us no notice. So in that particular case, we had no idea this was coming in. We saw it, and then we asked, and they says, "Oh, well, yes, we just put a call in." It's like, well, okay, but that's not helpful. I mean, it's not unhelpful, but the timing is poor. But certainly, if their EIS is done, if their TIAR, maybe not the entire EIS, but the TIAR is done, they should have been talking to DOT, and we certainly will tell them that. Most of the major developers know that. The problem, of course, is some of the newer developers, or the developers that don't practice in the state of Hawaii very often, or have hired consultants who might not do land use commission matters very often. And, there's no requirement to consult with us. Our purpose, we hope developers understand that our purpose is not to make their life horrible. It's actually to smooth the process and identify the issues. I'm taking probably more time than you need, but yes.
So, Mr. Yee, this is the chair. Are the processes that you're describing different in any way if the petitioner is actually a state agency, such as the Department of Education?
No. And logically, it should really be easier, right? Because it's another state agency. So logically, for a private petitioner, we have to be a little more careful because we are not. We don't own the land. It's their land, it's their proposal. With a state agency, logically, you would think we would have more say and can push harder on some of this. But really, it's in my experience, it's dependent on the agency rather than the type of character.
Yeah. Okay, please proceed.
Mr. Yee, I'm just curious, do you have an in-house, or what is the process in dealing with the public trust doctrine review and the cultural, cultural significance review? What is the process in the OPSD?
So we rely very heavily on the State Historic Preservation Division for the review of the Archaeological Inventory Survey, which is, of course, a very major component of the Kapa'akai analysis. I will tell you, just frankly, our analysis of the cultural impact section is pretty limited. We can look at the process and methodology they followed, but it is very hard because there are no clear criteria for determining adequacy. So we could look, for example, at the cultural impact assessment to say, you only talked to 5 people. Or we could look at it and say, you sent this out once and then you've never done it again. But, other than that, it's hard. Honestly, that CIS is tough for us. The AIS is different. The Archaeological Inventory Survey is a little more set in how you're supposed to do it, and we can analyze that a little better. But we do rely very heavily on the State Historic Preservation Division and their comments. And then we go back to your previous issue of how do we get comments from out of state.
And just a follow up on that, I just was curious, is there anybody specifically, is there contemplated that you would be hiring somebody or relying upon somebody within your agency or group of agencies to do the?
No,
because I can see that being a benefit to trying to get projects to the LUC and limiting or make things smoother and faster if that type of analysis is assisted to the developers.
Right. Yeah. So a lot of the expertise you're talking about does not lie within OPSD itself. It relies, it exists in other state agencies. So you talk about public trust as well. So CWRM is Commission on Water Resource Management. We consult with to get their input. But we do not have a person sort of devoted to being the public trust expert or the Native Hawaiian, cultural resources expert. We rely on the state agency to give us the information.
Maybe the new attorney.
Anything you want to give to the new attorney is perfectly fair game. Emphasis on the new attorney. Next slide. Oh, I'm sorry, maybe we're on the next slide. Oh, yeah, okay. Let me just briefly talk. I think you'll probably discuss this as well. But one of the things we do that's important is we have conditions, and the conditions have to be supported because we need to demonstrate constitutionally that that there is a nexus and a link between what the conditions imposed and what the interest is or the impact is. And then as well as a rough proportionality between what we're asking for and what the impact is. So for example, if there is a new development that will cause significantly increased traffic, we don't, based on that, say, and therefore you need to create $1 million park, because the park just isn't related. There's no nexus between a park and traffic. Or if the amount of traffic would require $100,000 in traffic mitigation, we don't say, give me $1 million. So it's not based on how much the developer can pay, or how much can we squeeze out of them. It's based on what is the impact from the development. Next slide. The first, number 8, which identify percent state documents and witnesses. I've compressed a lot of work into just a sentence, but it's a lot of work, and I'm just going to leave it right there. On the DNO, just to let you know, a district boundary amendment DNO can be over 100 pages. And if the Office of Planning agrees with the basic conclusion that the petition should be granted, it just makes sense to us. And what we do is we'll let the developer draft the DNO, and then we will review and revise it. And that's still a lot of work, because if we have just a little time, we will review it to make sure that it's accurate and the conditions are adequate. So, but if we have more time, and there's always a little bit of a tension between what the LUC wants and what OPSD asks for on time. But one of the things we can do if we have more time is we look through the record to make sure that the representations that the petitioner made are included in the DNO. And the reason that's important is one of the conditions that's included in all of the DNO's decisions and orders is that the petitioner substantially comply with the representations made to the Land Use Commission. But no one goes through a transcript to figure out what the representations are. The only possible way you can figure it out, if it's not explicitly stated as a condition, is if you go to the DNO itself. And it's a big document, and even then it's a big document, right? So we want to make sure that at least the DNO has those representations contained. So if the petitioner says, we will develop bikeways, then we want to say, petitioner said that they would develop bikeways. Because sometimes you can't sort of put every representation in the conditions. It might be something like the petitioners represented or stated that they would perform the mitigations outlined in the EIS or an equivalent or better mitigation. Just because there's a lot of stuff in the EIS and we can't include it all within a condition.
Mr. Yee, Mr. Chair, I'd like to ask Mr. Yee a follow-up question. Wouldn't you agree that, and this would apply to even the proportionality, the nexus, to the extent that the petitioner agrees, that is always the better outcome.
Yes.
So even though it may not be proportionate or even maybe more than, if the petitioner agrees to a particular mitigation or if the petitioner agrees that these are the representations, then that should always be part of the record, part of the DNO. Would you agree?
Yes.
Yeah.
Yes.
Yeah.
And just to build a little bit, it's sort of like, if a tree falls in the forest, right? If the petitioner agrees to a condition, whether it's proportional or not is almost irrelevant, right? Because no one's going to appeal the decision.
Right.
So yes, the fact of the petitioner's agreement and the fact of the petitioner's agreement is important. It should be included in the DNO. In addition to doing that in reviewing the DNO, we also take time to make sure that all of the facts that are in there, and this occurs, these are sort of more nuanced, but it might be something like we wanted an issue on the market study. It probably doesn't affect maybe your final outcome, but we wanted to make sure that we're not saying building tons of luxury homes is a great thing. What we really want to say is, and you're building this amount of moderate price homes, because that's the important fact that we want to make sure is included in there. Or it might be something from our expert that said, yes, that's true, but remember that if this, if other things happen, then further mitigation may be required. So the petitioner has their point of view. They're not trying to, I'm not accusing the petitioners of doing anything wrong, but sometimes you need a fuller record from a different point of view. And if we have the time, we try to do that as well. And of course, there's always the wordsmithing. Sometimes we disagree on the nuance and tone. So if we have the time, we'd like to work on that. And then very, very quickly, if we're not in agreement, if we say, no, this petition should be denied, we will draft our own DNO. It happens rarely, but if it does happen, we would offer to draft our own DNO. Next slide. Post-hearing motions. Scott talked about several of them. I'm happy to answer any questions about them. All I will say at this point is the complexity and time requirements vary widely. Some are quite simple. Some are even more difficult than the initial district boundary amendment. So I will just leave that and be happy to answer any other questions. Next slide. Important agricultural land designations. There's a constitutional requirement that the state protect important agricultural lands. Okay, I have to remember I have this long rant about how the state could do more to protect agricultural lands. But let me just say, with respect to IAL, we're not a party. Statute doesn't make us a party. We are available to, we do provide comments. Often because we're the only one there. I mean, for some farmer petitioners, farmer petitions, it's the petitioner and us and DOA and nobody else, not even the public sometimes. So it's important you get another point of view, and we do. We will critically analyze their petition. Some people, of course, will may say, well, if they want to designate, why not? The Office of Planning does take the criteria seriously and does examine, well, you wanted this much, but really, this is the only good land that you're proposing. And so that's the land we think that should be designated. And I will, let's see. Yeah, so anyway, so we are involved and hopefully you will find that our involvement is helpful. Next slide.
Oh, Mr. Yi, yes. Sorry, and I apologize for asking so many questions, but I want to follow up on your comment that OPSD supports important ag lands, ag lands in general. So for purposes of the Land Use Commission, many times there are competing state policies, especially DBAs. They are seeking to change zoning from ag to urban but outside of ag. And they're going to put it in a renewable energy project, or they're going to put it in something other than ag. So, I look to OPSD to really provide that kind of state policy perspective. So does OPSD, do you look at the competing state interests, policies, when you evaluate, whether it's a DBA, whether it's a, whatever the SUP, whatever the matter may be that you're participating in, is that a consideration by OPSD?
So the answer is yes. And how we do it is, it can be a little complicated. And if I may, if you can wait 4 more slides.
Okay.
I will absolutely get specifically to that question because I think it's a really, really good one. Next slide. Just to let you know, on IL petitions, a farmer may come in and ask not only that their land be designated as IL, but also that additional land be reclassified. So ag land gets protected and additional ag land gets converted into urban. We have never had a case like that. And what I could have put on this slide is just, a picture of a bunch of poker chips, because all I really want to say is if that ever happens, all bets are off. The process is going to be different. We've never had to face it. We're going to have to figure out what to do. We don't really know what we would do then, and we will face it when it comes. And I think we'll deal with that on another day. Next slide. Special permits and declaratory petitions. These are 2 very different processes, but OPSD's actions are actually quite similar. Scott talked about what they are, so I won't get into that. For special permits, we are not a party unless we intervene at the county level. Scott said no one intervenes before you. That's true. We are OPSD, as well as the Land Use Commission and DOA, I think, are mandated recipients of the copies of the special permit applications. So we are supposed to be getting copies of every special permit application that's filed at the county. That is often true. Maybe not always, but it is often true. So sometimes we'll get these special permit applications every once in a while anyway, and we're like, what is this? Generally, if there's no prejudice, we don't raise a fuss. But obviously, I just mention it now because if anyone is listening, please make sure you get us those applications because it makes our life a little easier. Declaratory petitions, again, not a party unless we intervene at the LUC level, which sometimes we do, sometimes we don't, because some can just doesn't require an actual intervention or does a case hearing. Next slide. What do we do within those? So this discusses them. I'm not going to go through all of that. Let me just say that we always provide you with comments. Similar to the other cases in which sometimes there's going to be no one there except the petitioner and us, it's important that OPSD, I think, participates, and we do, so that you have another point of view. We might be in agreement, but at least you have someone else who looked at it and said, yeah, I agree. Or I agree with everything except be aware of that. And we'll try to give you the information and the analysis, in fulfilling our role with the Land Use Commission. The LUC has also allowed us to participate in a meaningful role in these matters, even though we are not parties. We certainly appreciate it. And we hope that our participation has been helpful to your decision making. Next slide. This is the issue on which we want to talk about this. It is a difficult question, and it is absolutely a fair one about how do you balance all of these different competing interests. So when someone comes before you, it's a nice piece of agricultural land. It's good agricultural land, but it's also good for energy. It's going to be great to create a sustainable future for on the energy front. It's also going to be terrific to provide housing. And so which one is going to happen and how do you figure it out? And this is not just difficult because the question itself is difficult. It's also difficult because these larger issues really cannot be adequately answered with respect to one parcel of property. Really, this question is look at the entire county, or at least look at the region, and say, where do we think growth should occur? Where do we think housing should be developed? What are the areas that we think agriculture should be maintained? If we do decide to go to urban, which ones are housing? Which ones are going to be industrial? Which ones are going to be for something else? And that process currently, under the laws that exist, is done at the county level. Those are done in county community plans, sometimes called development plans, sometimes sustainable community plans or sustainable development plans. But regardless, there are regional plans, and sometimes those regional plans are added together into an island plan. The counties have been pretty good about, well, the process the counties follow have been good. Sometimes they're a little slow in updating. And so in the past, we've sometimes had problems when someone would come to us and they say, I'd like to urbanize this area. It's not consistent with the county plan, but the county agrees that we should be urbanized. And the county will come in and say, yeah, you know, our county plan really should have been updated. So what do you do? One of the criteria that was mentioned, I think it's 205-17, 205-18, one of those two. Consideration of the county community plans is one of the statutory criteria you have to do. So this is a long explanation in saying, technically, you have to look at how do you balance. One thing you do is to look at those county plans and to figure out how the county decided to balance, you know, agriculture, energy, housing, all those other things. Sometimes, but as a practical matter, sometimes that is more helpful than others, because sometimes those plans are outdated. And then you get into the question of, well, even if this land is slated for housing, is it appropriate to do housing now? So if you're saying this area should be urban, but you know, urban is here and you know, everything else is agriculture. Maybe you don't want to develop agriculture here today, right? Because you're gonna have this great big gap of agriculture in between. Really, you should have more of the urban development closer to the rest of the infrastructure, closer to other urban developments, rather than putting, you know, one spot over here. And so that's also a decision you have to reach. OPSD certainly looks at those competing issues, and the loss of agricultural lands is of good agricultural lands. Not all agricultural land is frankly good, but the loss of good agricultural lands is frequently a concern. We have tried to address it in the past sometimes with mitigation. We have asked on one occasion, I think we asked the developer to designate other lands as IL. In other occasions, we've asked the developer to put in a transition plan for the existing farmers. In some cases, we don't require anything. It really sort of a case-by-case basis on what to do. And of course, in some cases, the answer is no. In some cases, you know, you may want to say, either it's not included in the county plan, which is the easiest, or if it is included in the county plan, it's not appropriate to do now. And there's no good answer to the question. There just isn't. It's a tough judgment call. And it's made more complicated by the fact that what you do is a contested case hearing. You don't do regional planning. So how do you, on a contested case for this parcel, decide how to balance the entire island? And in some ways you can't actually do that entire balancing. You just have to sort of look at how it fits and then make your judgment. So not a very good answer, and there are limited. And part of it is, by the way, just to say, part of this is that we have the statutory, you know, construction that we have. I mean, it is what it is, and we can go ask the legislature for changes. There are any number of potential changes we could maybe make to make improvements, but that's a political process, and that is beyond certainly my scope of discussion.
This is the chair. Just doing a time check. How much more do you think you've got?
I have almost done.
Please proceed.
I'm sorry, Mr. Chair, can I just make one comment? Sorry. So Mr. I guess the challenge that I have with sometimes the plans may be outdated is that there is what we are cutting short is a community engagement process. And what's happening is that because normally in the county planning, you know, when they update, there is a public process to do that. But when we unilaterally make a determination, we being whether it's the county, a developer, OPSC, or even LUC, what we're cutting short is a community in that process. And so that is a real, that's a real concern to me. And I think that's gotta be factored into some of these issues, is the role of the community in that process when we are changing something or raising an issue that has not been fully vetted by the community planning process.
That's an excellent point. I agree. Next slide. All this was to tell you is that Chapter 205 and Chapter 343 are different. And the fact that you accept an EIS doesn't mean you're going to just say, yes, the petition should be granted. So we're not litigating whether or not what conditions should be posed on the project when you accept the EIS. At the same time, when we get to the petition hearing, you may very well see additional issues raised and demands for more information than was contained in the EIS. All of that is I think, perfectly fine and will happen. Next slide. Basically, I just briefly want to say, one of the things that sometimes happens is there are motions for reconsideration. The land use, the OPSD puts great stock in the validity of prior decisions, and we respect those prior decisions. So there have certainly been examples in which someone moved for, there was a district boundary amendment, and there were 7 commissioners, and 5 were in favor, 2 were against, and therefore it failed because you didn't have 6 members. So they filed a motion for reconsideration. Why? Because at the next meeting, there were 9 commissioners, and the 2 missing commissioners might have voted in favor of the petition originally. OPSD's position, deny. Even though we supported the original petition, our position is once the LUC makes a decision, we're going to respect that decision unless there's new information. I mean, if there's new information, you know, a new analysis, something that was missed, fine, but not just because we got a different group of commissioners. And the same is actually true for motions to amend. When they file a motion to amend, if they just disagree, generally our fallback position is no. You can't get a DNO, let the statute of limitations to appeal pass, and then years later come back and says, no, I don't like this because I just disagree with the original decision. No, you have to come up with a reason why. And this goes even if we really think that this decision could have been better. And there are some older decisions where the sophistication of the analysis was frankly different. The information we could give to the LUC was different. There are cases in which an EIS was not required, public trust was not considered, and even then, OP does not propose the addition of, let's say, a condition that we thought, oh, this really would have been the condition we would have imposed initially, because they got their entitlement and the decision was made. And while it's true that business certainty is not a highly discussed value, nevertheless, it is an important part of any type of land use process. That businesses, once they get their decision order, have to be able to rely upon their entitlement. And so we respect that, and that's our position. Stipulations and importance of public participation, very quickly, is simply deals with the issue of sometimes petitioners come to us and ask us to stipulate to a DNO before the hearing. And while that might make your life a little faster, OPSD won't stipulate to the actual DNO. We'll have a position, but we won't stipulate to the DNO until after the public hearing. For OPSD, it's important that the public have an opportunity for meaningful participation. That means that OPSD won't come to its final conclusion until after we hear from the public. So we want to be able to hear from them before we stipulate to a specific DNO, in case the public tells us something that we were not aware of or we had not considered. And with that, the next slide, I think, is just an opportunity for questions. But if none, I would just want to thank you very much for the opportunity to present.
Thank you, Mr. Yee. Commissioners, do you have any burning questions or or?
Yeah, Chair Gary Okuda, if you don't mind, I keep it short.
Keep it short.
Yeah, Mr. Yee, based on all your years of experience before the Land Use Commission, can you tell us the number one thing you think we should do to be good commissioners?
First of all, I'm a huge supporter of the LUC. I have told people both to the Supreme Court and to elsewhere that the LUC is composed of uniformly talented individuals within their field. And I don't say it because I'm going to appear in front of you again. I really have said that. There are times in which I think it's important that you understand not just what you want to do, but what you're statutorily allowed to do. And so there are times in which I sometimes think that you're trying to do something you're not going to be allowed to do. And in some ways, that's kind of not my place, because, I'm not your attorney. So, you're talking about, honestly, you're talking about special permits. I'm not aware of any statutory or rule that allows you to revoke a special permit. But, if you want to explore that and go through that process, I'm not going to stop you.
Yeah, well, okay, thank you. Well, at any time, I'm sure, because you're not the so-called shrinking violet. I don't think any of us take any criticism, constructive or otherwise, negatively. So if at any time you think there's things we can do to improve or me to improve, I will. And I know one of the things is to shut my mouth, which I'm going to do right now. Thank you, Mr. Chair.
Thank you.
Thank you. So let me call on Mr. Orendanker for some advice here relative to the clock. Obviously, we would like to take a lunch break at this time. And Ms. Bass is scheduled at 1:30. What do you recommend, Mr. Orendanker, in terms of a lunch break and rescheduling for Ms. Bass? Also, please be aware that over the lunch break, you will lose two commissioners. Ms. Cabral, Commissioner Cabral has to head back to Hilo, and Chair Giovanni has another commitment that he can't get out of. So, second Vice Chair, Mr. Ohigashi, Commissioner Ohigashi will be taking over the gavel when we resume after lunch. So, Mr. Orendanker, what is your advice?
I would defer to the commissioners as to how long they want to take for lunch. Yesterday, we seemed to go fairly quickly. So 45 minutes for lunch, is that acceptable to everybody? Okay, then we can resume at 12:35 or 1:35 actually, excuse me, 1:35.
Okay, I think that's a great suggestion. We will recess at this time and resume under the chairmanship of Commissioner Ohigashi at 1:35. Before I depart, I just want to thank everyone involved in the Office of Planning and Sustainable Development for your presentations today. I always learn something new and helpful, so thank you very much. And I'm sorry I'm going to miss Ms. Bass's presentation. I enjoyed her presentation last year, and I'm sure the update would be of value, but I will catch up with her as well. So with that, I am going to recess the meeting for now, and it'll reconvene at 1:35. Thank you all.
That was a love tap. That's okay. That's me. Calling back to our training session at 1:35 p.m. Thanks, Mom. And I guess we're about to continue with our training session with Dan Orendanker leading us today.
Thank you, Vice Chair Ohigashi. The next section that we're going to be talking about is sustainability and climate change. In our rules under 1515 C24 and 25. We require petitioners to give us information with regard to a variety of issues that are sustainability and climate change related. At the current time, they're not a decision-making criteria. However, because of the way our statutes tie back into the state plan and things like that, we are required to take them into account. And in order to explain the interaction of how the statutes work and what sustainability and climate change are, we have our sustainability coordinator, Ms. Danielle Bass, to tell us all about it. And I'll turn it over to her from here.
And aloha back and welcome to the new commissioners. It's a pleasure to meet and work with all of you. Looking forward to working together. Again, my name is Danielle Bass. I'm the State of Hawaii Sustainability Coordinator. That's a position within the Office of Planning and Sustainable Development. Been in this role for about the last 5 years. So we're going to be, I'll be providing you an overview of planning for sustainability and climate change as it relates to your kuleana as land use commissioners and the dockets before you. So we'll be going over policies and such. So next slide, please. We'll be, again, going over the roles and responsibilities of the Office of Planning and Sustainable Development, how those roles expanded over the history of these 5 years, the establishment of the statewide sustainability branch, which is the branch I'm housed in within the Office of Planning and Sustainable Development. We're going to do a brief, very quickly overview of climate change and global warming, as well as Hawaii's work towards climate change adaptation, our state sustainability and climate targets. Those are we need to achieve something by 2045. So there's quite a lot of those policies codified in our statutes, as well as the general summary and recommendations of the 2050 Sustainability Plan. Next slide, please. So going into the Office of Planning and Sustainable Development, next slide. You'll see in the recent years, it's 2022. So really very recently in the last 2 going into 3 years, our statutes in the Office of Planning have significantly changed. Not only were we renamed as now the Office of Planning and Sustainable Development that my colleagues have actually presented on today, earlier this morning with you, and the expansion of the Environmental Review Program, as well as the inclusion of the Environmental Advisory Council, which is attached to the OPSD. But we've also expanded to work on climate adaptation and sustainability planning and coordination, as well as in terms of our coastal and ocean policy work, that has also expanded into sea level rise adaptation coordination, which my colleague from the CZM program presented to you earlier this morning. Next slide, please. So briefly, to just show to you the statewide sustainability branch. Again, it was recently created in 2020. Currently, there is only one staff, that is myself. The Office of Planning and Sustainable Development continues to work with the legislature and the governor's office and the administration to expand the staffing and financial support to that branch. This branch has a wide variety of roles. It is required to develop, organize, and promote policies and programs to assist the state of Hawaii, not only our government agencies, state and county, but our private sector, our non-government organizations in terms of sustainability targets, as well as our climate issues. Next slide, please. So, what is climate change? We know from climate science and data collected all the way dating back to the 1800s that we are experiencing as a world changes in global and regional climate patterns from the rise in average global temperatures due to the increase of human greenhouse gas emissions. Next slide, please. So going a little deeper into the climate data from our own Mauna Loa Observatory, which is often referred to globally in terms of our climate science data collection, we see that currently our CO2 emissions as a world is 418 parts per million. Now you'll see in the slide that safe levels of atmospheric concentrations of CO2 is really 350 parts per million, excuse me, of CO2. So we are far beyond that 350. And the last time CO2 levels were actually this high, humans did not exist. This is why climate change is such a very important issue, not only to the sustainment of our own generation, but for future generations of humanity moving forward. When you think about parts per million of CO2 and greenhouse gas emissions, you can actually convert that into carbon budgets of your operations, of your developments, which is really your carbon footprint. Next slide, please. Now, expanding beyond CO2, you do hear a lot about the carbon dioxide, which is quite prevalent, but there are other greenhouse gases that actually have high global warming potential as well. This includes methanes, nitrous oxides, hydrofluorocarbons, perfluorocarbons, as well as sulfur hexafluorides. So the methanes, you'll start hearing that that's released in our landfills, in our waste management practices. And that's why you're starting to see more sustainable efforts even in our waste management. Next slide, please. So globally, you're seeing that the United Nations is even taking action with among the 196 UN states within the United Nations. And first and foremost is the Paris Agreement. 196 countries across the world have agreed to this agreement, which seeks to lower our global warming potential through our greenhouse gas emissions to hit only by limiting the temperature increase of 1.5 degrees Celsius to pre-industrial levels. Again, that's dating back to our data, going back to the 1800s from what we recall. Okay, moving forward to the next slide. Concurrently, the United Nations has also created what are known as the 17 Sustainable Development Goals. These are supposed to be intertwined, if you will. Think of it as a weaving with the Paris Agreement of greenhouse gas emission reduction. So not only are we striving to lower those greenhouse gas emissions, but we're really trying to proactively, sustainably develop as we're trying to meet the many serious issues affecting humanity, including quality education, including affordable housing, including equity. We want to make sure as we strive to move forward towards this progress for sustainable development, this is intertwined with greenhouse gas emission reduction. Next slide, please. So what about Hawaii? Next slide. We see that we are experiencing climate change impacts now. We can see that through our coral bleaching, excessive rainfall, and excessive drought. During La Nina years, which is what we are within right now, we're seeing significant amount of droughts in our neighbor islands, specifically in Maui and Hawaii counties. Concurrently, when our climate scientists and data collectors show that we're actually that the globe is changing back to El Nino in our region of the globe, we'll see more extreme rainfalls. Okay, so this is kind of like a back and forth of the constant changes affecting Hawaii. So you see too much rainfall, you see not enough. Additionally, we are islands, so we're seeing the increase of sea level rise, we're seeing coastal erosion, and this is again because of the global warming potential that the globe is experiencing, polar melt in the polar fields, which is adding to that sea level rise. Next slide, please. In terms of what our state of Hawaii is doing, we actually have quite a few climate adaptation resources available, dating back to 2017. So within the last 5 years, the state of Hawaii has documented this really strongly. You see that in our Hawaii Coral Bleaching Recovery Report, the Sea Level Rise Vulnerability and Adaptation Report published by the Hawaii Climate Commission, the State Hazard Mitigation Plan, which is actually being updated in 2023. It will actually include more sustainability and climate issues as we look at hazards affecting our islands. My colleague from the CZM program also noted that they have produced the managed retreat feasibility strategies. This is something in terms of land use. Do we need to, what do we need to do in terms of very vulnerable coastal communities, right? This is a little more farther out, not immediate, but how are we looking at that? Do we need to contemplate managed retreat? The Department of Transportation also has resources that include Coastal Highway Program Report, as well as their Adaptation Action Plan. The CZM program has, of course, produced the Ocean Resource Management Plan so that we can protect those natural resources, and the South Shore Promenade Coastal Open Space Study. Finally, we recently published last year the Hawaii 2050 Sustainability Plan, which legally serves as the State of Hawaii Sustainability and Climate Adaptation Plan. And it is intertwined with the Hawaii State Planning Act. So these things are connected. Next slide, please. Going into policy, what the state of Hawaii is doing. Next slide. Here we go into the targets for sustainability and climate change. In 2020, there was a requirement for our state to actually reduce our greenhouse gas emission levels by the year 2020 to 1990 emission standards. I'm pleased to report that through all this collaboration, as well as the hard work of our colleagues in the Department of Health, that we have actually met those 1990 emission levels and are below them. So as a policy, we need to start moving forward to even lowering our carbon and our greenhouse gas emissions footprint moving forward. Next slide. Another statutory target is a ban on coal power. You're starting to see this more prevalent in our news reporting. By this year, coal operations will cease at the end of this year. And you're gonna start seeing our coal producers on this island to start shutting down that process in September. But really, they need to conclude by the end of this year. So when we're seeing these prohibitions and these requirements to lower our greenhouse gas emissions and our fossil fuel dependency, we need to, of course, compensate for that in terms of just increasing our renewable clean energy opportunities within the state. Next slide, please. By 2030, there is a requirement on the Department of Agriculture to double food production and increase food exports in 8 going on 7 years away. So when we think about our AINA, when we think about our ag lands, there's a requirement on the state of Hawaii to double our food production. Additionally, this year, the state legislature has actually expanded and supported local food production, food self-sufficiency and sustainability by codifying local farm to state meal goals. So for the Departments of Education, Public Safety, Health, Defense, and the University of Hawaii system, by 2030, again, 8 going on 7 years away, these state entities must include 18% of local food served within their foods procured by these departments. This is because these are heavy consumption of food departments, right? When you think about the University of Hawaii, the meals that they provide the students, the Department of Education, same. Our prison systems, what we're feeding our inmates. Our Department of Health, what we're feeding those patients in the state hospital. So this is why we're starting to diversify and require these local farm to state meal goals. And by 2050, 50% of food sourced by these departments must be produced locally. So when we're thinking about the future of our land uses, the future of our agricultural lands, we need to be mindful of how are we meeting these goals of 18% by 2030, 50% by 2050? Moving on to the next target. As an attempt to continue, a very diversified attempt to continue to reduce our emissions within the state of Hawaii, the state legislature last year codified a law to actually reduce the carbon footprint of all of the state's fleet vehicle systems, right? So by 2030, all of our state fleet, all of those state cars you see are required to be zero emission vehicles. So this is an opportunity when we're thinking about our transportation impact, right? Just the commuting impact across all of our islands. How do we reduce that carbon footprint? You see the state leading that way through a requirement such as this and that transition. That requirement is not on the general public, it is just on the state government. Next slide, please. Additionally, we have the Aloha Plus Challenge, which are 2030 sustainability goals. I want to highlight this because you might have heard messaging about the Aloha Plus Challenge, which highlight clean energy, local food production, natural resource preservation, waste reduction, smart sustainable communities in our built urban environments, and green workforce development. I want to stress, however, that as important as this challenge is to meet these respective goals by 2030, they are not legally codified as the other laws I have explained and will continue to explain throughout this presentation. This is a legislative resolution of goals in which the legislature is urging all of us to meet. These are not mandated. They are not laws. Next slide. Continuing in our sustainability and climate policies, by the year 2035, the state legislature has mandated that all University of Hawaii campuses, as well as Department of Education campuses across the state, must be net zero. This means that they are consuming the same amount of electricity that they are producing in a clean way. So you're going to start seeing a lot more projects and developments in terms of photovoltaics on these buildings, energy storage in terms of batteries, and anything to diversify, lower that carbon footprint of those facilities, as well as generate clean, renewable energy opportunities for those facilities. This is how you even out the carbon footprint for facilities, even pre-existing facilities. Next slide, please. Going on to state facilities, there are mandates that future state facilities, if developed, must be at least LEED Silver. So when you think about facility design, there is a sustainability certification for LEED, which actually looks at not only your energy consumption and production like we just talked about, but also waste management practices. Is it only just regular trash that's going to go to the landfill? Are we recycling any of this trash? Are we composting any of this trash? How does that impact the landfills on the island? How does that impact the composting availability on the island, right? This goes to that zero waste movement you're starting to see. So waste management gets to be very important in terms of facility operation, design, building, and maintenance. We've heard a lot about water. We want to make sure our water resources are clean. We're not over consuming, and we are providing enough water resources for the users, but we're not over consuming to make a terrible impact on the INA surrounding the facility. So that is what LEED certification can also do here. In terms of design for state buildings, and this year the legislature actually passed requirements that all new state facilities must maximize energy and water efficiency, energy generation potential, as well as the use of building materials that reduce the carbon footprint. So this is what we're starting to see more transitioning in terms of current facilities operation and maintenance. Next slide, please. The 2045 statutory targets. There's been a lot of talk about these targets. There are 3 of them. The first being, of course, the 100% renewable portfolio standard by the year 2045. Within that law, there are benchmarks. So by the year 2030, the state of Hawaii, as well as its electric utilities, must meet 40% of electricity generation, clean, renewable electricity generation that is renewable, 40% by 2030, 70% by 2040, and 100% by 2045. So when these types of projects, developments start coming forward, we need to be mindful of these benchmarks and that state target as well in those decision-making opportunities. Secondly, there's a zero emissions clean economy target by 2045. This law requires the entire state of Hawaii, not just the government, Hawaii, to sequester more atmospheric carbon and greenhouse gases than we emit as quickly as practicable or by 2045. So that is a net negative requirement. When you start hearing about carbon neutrality, this is what you need to think about, this law, because we need to sequester, we need to collect more greenhouse gas emissions, put that in our soils. We need to start reducing greenhouse gas emissions more than we emit, right? So again, that goes back to your carbon footprinting, your carbon budgeting, so that we can hit we can hit carbon neutrality, and by 2045, hit net negative in terms of carbon consumption and greenhouse gas consumption and emissions. Next slide, please. Finally, by 2045, all state and county facilities must reclaim water, 100% of its water consumption. It must be reclaimed. This is water recycling, plain and simple, with the exception of potable and drinkable uses. So, you know, when you gotta go to, you fill your water bottles, no worries. But in terms of those sinks, in terms of those toilets, in terms of irrigation surrounding that facility, that needs to be, that requirement means that that water needs to be recycled according to law. So you're starting to see the state and the counties making these, imposing these mandates upon themselves. And this is something that we can consider for even a broader impact for all of our state. Next slide. Finally, in terms of the statutory targets, the 2050 statutory target, mandatory cesspool upgrades by 2050. Across the state of Hawaii, it is estimated that there are 88,000 cesspools attached to our residential communities and homes. There is a requirement on these homes, on our counties, on our state, on our Department of Health to convert all of these cesspools to be upgraded either through septic systems or through sewage management, but they must cease to exist by 2050. So that is the final sustainability statutory target that our policymakers have codified in our statutes. Moving on into the Hawaii 2050 Sustainability Plan, I'm going to do a brief overview of our process and public outreach. In terms of our process, we had a very extensive public outreach. This is during the middle of the pandemic in 2020, and we're very proud that we actually heard from nearly 1,000 people on virtual platforms. We couldn't go island to island. So what was great about that was we had people from other islands interacting with each other and understanding that these communities, these rural areas, these vulnerabilities are regionally based and can be different based on which island and region and community you're from. We actually reviewed over 150 of our laws and policies in terms of Hawaii sustainability and climate planning. We engaged with over 65 state and county reviewing agencies and had over 230 participating organizations in this outreach, all to whittle this back down to a easily consumable, understandable 8 focus areas, 38 strategies, and 262 recommendations. This plan is available at the Office of Planning and Sustainable Development's website in our offices. If you would like a copy, please reach out to me or the LUC staff. I'll be happy to provide to you. Next slide. In terms of the Hawaii 2050 Sustainability Plan, what we wanted to achieve was alignment of our state laws, our state plans, our county climate and sustainability plans, the Aloha Plus Challenge that I presented to you earlier, the Governor's Sustainable Hawaii Initiative, all in alignment with these United Nations Sustainable Development Goals that over 196 countries signed on to give that final product of the Hawaii 2050 Sustainability Plan. Again, by law, this plan serves as our sustainability and climate strategic action plan for this decade between 2020 and 2030. It will be revised when we get closer to the 2030, 2040 decade. So this is what we're working with now. Next slide, please. Going into our recommendations, we have identified 8 focus areas recommended for this decade of action. Ranging from, first and foremost, coming out of the COVID-19 pandemic, we know we need to promote a sustainable economic recovery. We need to continue to reduce our greenhouse gas emissions. We need to improve climate resilience. That's the adaptation, the sea level rise. Rebuild or building our urban area to address urban heat impacts, all of these climate adaptations through climate resilience, advancing sustainable communities in our urban areas, advancing equity, making sure we're not disenfranchising different communities, vulnerable populations, and that all of Hawaii can be equitably, affordably, sustainable, and climate resilient. We need to continue to institutionalize sustainability throughout government, preserve our natural environment, of course, through clean water, marine resources and ecosystems, and natural resource protection. And all of this while perpetuating the traditional ecological knowledge and values of our Kanaka Maoli, our indigenous people who have been here before we all moved, before all of these residents, our 1.4 million residents and this population. We need to go back to our roots and learn through that perpetuation of how we can move forward. Next slide, please. Again, I already presented on these 8 focus areas. If you take a look in the plan through sustainable economic recovery, three of these strategies focus on agricultural diversification and expand into economic diversification, as well as lowering our tourism footprint. Next slide. In terms of reduction of greenhouse gas emissions, not only do we need to continue to manage, measure, and maintain greenhouse gas emission reduction, but incorporate this into our decision-making processes, our planning processes, and et cetera. And start promoting energy conservation and efficiency through outreach communication. So more focusing on composting, waste generation, alternative modes of transportation, all of these collectively to reduce our GHGs. Next slide, please. In terms of improving climate resilience, again, integrating adaptation and resilience into planning and implementation and decision-making, as well as implementing actions to improve the state's resilience to climate change. This even goes into hurricanes. How can we strengthen our hurricane shelters to make sure we are stronger as a people, and our hurricane shelters are even improved and adaptable, since we know that storm systems are actually increasing and more severely. In terms of advancing sustainable communities, advancing smart growth initiatives, and sustainability in our operations and design. Next slide, please. In the focus area to advance equity, how do we implement these strategies, right? We've identified opportunities to implement these strategies to make sure this is more equitable and affordable for our people in Hawaii, as well as through institutionalizing sustainability, that focus area, ensuring that these policies are starting to align and not contradict with each other. We want alignment when we're striving for this future. Next slide. In terms of the focus area to preserve our natural resource, or our natural environment, we want to continue to improve our water quality. We want to ensure that we have enough water supply for future generations, not only now, but for our future. We want to continue to preserve and protect our marine ecosystems and ensure that they are protected from more climate change impacts as we see this data and science continuing to come through. We need to continue to protect and manage those watersheds. Again, we know that our watersheds lead to more water on our islands, which of course is a source of life for all of us as we coexist with this natural environment. So multiple strategies identified there to achieve this focus area. Next slide, please. And again, to lift all of this up, perpetuating our traditional ecological knowledge and values throughout all of these focus areas. It's not one or the other. It's all of these integrated together in alignment. Next slide, please. I just wanted to mahalo the Land Use Commission and the commissioners. Earlier this year in April 2022, the Hawaii's 2050 Sustainability Plan actually won a National Merit Award for Excellence in Sustainability from the American Planning Association at our national conference for the state and regional plans category. That's from the APA Sustainable Communities Division. So I want to mahalo all of you for that opportunity. And just mahalo for the support. It really meant a lot to see the LEC there with me as we accepted this award. So it just shows that collaboration. And finally, I just wanted to end this with the kuleana that our best preparation for tomorrow is doing the best you can today. So thank you for your service and support of the state of Hawaii, and I'm available for any questions. Mahalo.
So,
We put on my button. Chair.
yes, Commissioner Kahele.
Oh, you gosh, I got maybe a comment and a question.
Sure.
You know, with all this stuff that's going on, you know, saving the planet, you know, and all these environmental issues going on, how does landfills affect your department or the state from accomplishing the goals that they're trying to accomplish by meeting the 2050 a goal?
In terms of landfills, from a sustainability lens, you need to think about the emissions generated from the landfill. So with all the waste just aggregated in a specific site, you start seeing the methane emissions release in those landfills, which go back to that slide from greenhouse gas emissions. You don't want to actually increase your greenhouse gas emissions. So we need to find opportunities to actually either capture those methane emissions and use that for renewable natural gas, or find alternatives to landfilling like composting.
Yeah, thank you. Because, you know, we've been wrestling with this issue about landfills on Oahu for many years, right? And they've come up with some alternatives, plasma arc, replacing landfills, but it's never happened. We've got two current landfills on Oahu that we know. One's in Nanakuli and one's in Waimanalo Gulch. So I guess with one taking construction demolition, I don't know how you guys are gonna be able to prevent the landfill from continuing to take construction demolition with all the construction going on here, right? You know, Kaka'ako, Kapolei, all over the island, we got all construction, either we're tearing down, demolishing, and then Waimanalo Gulch been going on for years. And I believe there's a cap or a term limit of when they can continue to operate. So is the state possibly looking at alternatives instead of trying to look for another location to build another landfill after Waimanalo Gulch closes down, I believe in 2027?
In terms of the state, I guess, who in particular, what agency are you considering?
Well, I believe yeah, they had a special use permit right up until I believe up until 2027.
Mm-hmm.
So it's kind of like the city's kuleana.
Yeah.
But yet the state is pushing for these environmental control stuff, right? And so, you know, I guess again, my question is, what can the state do to try to prevent another landfill where we're going to be experiencing all these problems with emissions and methane gas, and we're going to end up with the same problem as we're currently having now with the current landfills?
Mm-hmm. Well, there was a law that was passed by the legislature in terms of limiting the availability of landfills in the proximity that they are developed to, adjacent to residential communities. In terms of a special permit, I'd have to actually defer that to the director of the Office of Planning and Sustainable Development. That might be a more appropriate a question she can answer. But alternatives, Commissioner Kale, is we can start looking into composting, definitely. And composting is actually quite limited on this island and other islands.
Okay, well, I guess my concern and my question would be, most of the stuff that's going there is municipal solid waste, stuff that's coming out of the homes, right? If they cannot be sent to H Power, they're going to still be at Gulf. So I don't know how, if the state would be able to come up with a, you know, again, a compost plant or something that would be able to accommodate the stuff that's coming out of the homes, municipal solid waste, that's not being able to burn, that's still going to the dump.
Yes.
Yeah, so anyway.
Yes, actually, that is something that is, you might see it at the legislative level. There's so much advocacy for composting, not only on this island, but on others. And we're really starting to have that conversation on a policy scale in terms of land use, waste management with our regulators at the Department of Health and even the counties. We need to make more progress on a policy level and in terms of financing composting throughout the state of Hawaii and our respective counties.
Thank you, Danielle.
Yeah, I just wondering for Daniel, what are the LUC doing with these these goals and everything?
Well, that gives me the opportunity to ask Danielle a couple of questions that she'll appreciate and probably make me pay for later. Okay, so from a pragmatic standpoint, when we're making decisions, what should we be looking for in submittals with regard to climate change and sustainability? I mean, other than the fact that, you know, we obviously don't have to be wary of projects that are being built in areas that are prone to flooding. What else should we be looking for?
Well, I believe that the LUC has already done a very good job in leading that through the administrative rules you folks have adopted. You're starting to see carbon footprinting, carbon budgeting in terms of projects coming before you. And I think that that's very helpful. We're starting as a state to really go into carbon footprinting and carbon budgeting through all these greenhouse gas emission reduction mandates. And so when we think about that, you need to think about just the scopes of those emissions. How direct are those emissions? And it's really interesting when you start talking about scopes 1, 2, and 3, you know, in the direct, if the material of that project, of that development is actually, you know, what is the carbon footprint, the impact of that versus even the transportation of that material, how it came on a ship, how it came on an airline, that's going to be your scope 3 indirect emission. So when you start thinking about carbon footprinting, when you start integrating that into your projects, these are really interesting conversations to have, is just the footprint. How much kuleana are we going to look at? The direct climate impact of building the home, you know, and whether or not the equipment is actually used, is collected from a renewable energy or a fossil fueled energy, that is a direct scope 1 emission versus the import, the scope 3 emission. So carbon footprinting is very important. And I think that that is a wonderful way to go. In terms of adaptation, so that's your climate mitigative way to integrate into projects, proposals, etc. In terms of climate adaptation, you can start looking about the use of the land. Of course, you mentioned sea level rise and proximity to that, but also in terms of adapting, how green is that space? How much concrete is around? How much actual foliage is nearby? We know that with additional concrete, there's increased opportunity for runoff into our marine ecosystems. So when we see urban areas, we can integrate more foliage, more local fauna, more trees to sequester carbon emissions, to provide urban heat island reductions in the development strategy. So these are ways through adaptation you can start incorporating or even thinking about it for future projects and proposals.
Okay, well, while we're kind of on the subject of carbon footprints, one of the things for some of the commissioners who weren't here are understanding is that one of the things that we ran into with the project was they claimed carbon neutrality, but for just so everybody's aware, that's measuring that as an emerging field. So Danielle's difficulty is what metrics is she going to apply, what measurements and things like that. So you may see some comments from OPSD that are not definitive, only because we don't know right now what to measure. But let me ask you another question though, Danielle. I'm sorry Brian's not here because he was talking about nexus on conditions, but given that the state goals and the state sustainability plan and the state plan in general, do you think it's reasonable to say to a developer, for instance, that one of the conditions on the project is that all the homes have photovoltaic on the roofs? Can we go that far? Do you think you think there's enough of a nexus between the sustainability goals and requesting that type of thing from a petitioner?
Well, of course, I respect all the decisions of the Land Use Commission, but you could actually start seeing alignment of ideas like that with the renewable portfolio standard, with the zero emissions clean economy target by 2045. In order to get to these, we need to include more renewable generating clean energy and storage capacity. So when we want electric vehicles, so to speak, in our cars, or in our homes, and in our own households, we need to ensure that there's an electrical charger. We need to incentivize, this is from a grander standpoint, right? From a statewide standpoint, we really need to start incentivizing our residents to have electrical vehicle chargers at their homes, right? They're not, you gotta, like, what is that phrase, in order, it's older, but, you gotta build it. If you build it, they'll come.
They will come.
Same concept, right? You need the charger. They're not gonna buy an electric vehicle if they don't have a charger at their house, right? Then you got to drive all around Honolulu for charge. That's not gonna work. It's gonna impose more hardship on the person, on the individual, on the public. Right. So we need to start thinking about opportunities to really connect our houses as electric vehicle charging stations, as storage capacity, right? Batteries, right? You're going to need a battery to charge the electric vehicle. And how does that relate to photovoltaics on your homes? You want to generate the energy. So these things are all interconnected. Now, whether the Land Use Commission wants to make that decision, I absolutely defer to you. But when we're talking about climate mitigation and sustainability, that's how I think we should look at it.
Well, will we be getting comments from the Office of Planning and Sustainable Development with regard to some things that we may want to require, like charging stations in homes on new developments and things like that? Is that something that you foresee the Office of Planning and Sustainable Development making recommendations like that to the Land Use Commission?
Well, again, I'm not the director, so I don't want to speak for the entire OPSD. However, we are definitely working together as an agency. And of course, there is a limiting factor of there only being one individual in my respective branch. And of course, my kuleana is to advise not only you, but all the state of Hawaii and the counties and the private sector. So I would hope so. I would like to see that. And, you know, I do see alignment with the RPS, with the zero emissions clean economy as opportunities to start aligning these types of projects. You know, there is, I mean, I am not a lawyer, so I would hope that Brian were here, but I could see alignment with those statutes.
Commissioner Kahale wants to speak.
Chair, just one more comment. If you buy me a Tesla, I'll buy the battery. But,
Got to get the charger too, yeah.
you know, and when I was referring to the Waimanalo Gulch, you know, and I gotta go back to these landfills.
Yeah.
We got them on every island. So your 2050 goal, does that also include reducing and finding more modern alternatives, again, to replace these landfills that's located in the native Hawaiian communities that we're currently being impacted by? You know, and I'm just curious.
Yes, in terms of the Hawaii 2050 sustainability plan, the state sustainability and climate plan, I do believe of the 262 recommendations, there is one or a few. I do not have them all memorized, and I apologize to you, Commissioner, but we did take on some landfill recommendations in there. And really it's just to reduce the footprint of landfills. That is a recommendation in the 2050 sustainability plan. It is a recommendation. And we wanted to see opportunities to convert the emissions from waste generation, including of landfills and wastewater treatment facilities, so that you can capture those emissions and convert them into renewable natural gases.
Mr. Chair, can I ask a comment?
Normally I would say no.
Don, go ahead, Commissioner Chang.
I'll make it quick. As always, Danielle, you are just so impressive and so energetic. I really appreciate your passion. This is sort of a follow-up on Dan's kind of question is, have you quantified impacts for purposes of mitigation? So, you know, can we tell, you know, if you build a certain amount of square footage or acreage, this is what your impact will be. Therefore, it's easier for us to quantify in more dollar values. So to make an appropriate mitigation measure.
No, I have not, nor has the State Office of Planning and Sustainable Development, nor has any state agency to my knowledge. However, from what I understand, across sustainability professions is that there are metrics and opportunities available globally for that. The state of Hawaii hasn't integrated it. And, you know, it could possibly be that the fact that the state sustainability branch is the lack of staffing becomes an issue, right? I mean, if there's only really the one individual, if there are no staff, I'm not going to impose anything. Right? I'm not going to come down with a hammer, right? I mean, there's no staff to come out with that metric, to post on our website, to integrate with our community, right? To help all of the other planning firms and agencies to start adopting that. So that lack of staffing really matters.
So let them know, that administration know that lack of staffing may be a signal to priority.
Yes.
Who wants to speak? Oh, Commissioner Okuda.
Thank you, Chair. I'd like to follow up on what Commissioner Kahele's landfill questions, because I think it was my motion that I brought in front of the Land Use Commission, which set the deadline to close down the Waimanalo Gulch landfill. Okay, and my comments aren't intended to negate any of that or anything like that. But following up on what Commissioner Kahele said, but just to give a short explanation, one of the reasons why I brought the motion and what in support of the motion was my view was that the standard of review on locating these types of negative public facilities should be the same as if the dump was going to be in Lanikai, I said, Kahala, or Portlock. And there's just something wrong with where somehow these types of facilities end up on the leeward coast. But I recognize the fact that we need a landfill, and without, commenting on what evidence which may or may not show up if the PVT matter ever ends up in front of us, there is going to be a certain amount of construction materials that have to be disposed of in a construction landfill, because it's a balancing test. But unless there's an alternative, if we have no construction landfill, we're not going to have construction. And then the question is, who's going to bear the burden of the fact that now we're not going to have jobs? Because some people would argue, the burden of not having jobs may disproportionately fall on, people who don't necessarily live out in Nanakuli or don't live out in Portlock, Kahala, or Lanikai. So my question is basically this: given the fact that at least the media reports that there's been difficulty of the landfill committees that the city and county is putting together to site new landfills, and there's these restrictions being placed by the legislature, wouldn't it be a good role for the state of Hawaii, the state government, to take the lead and try to facilitate among all the counties, giving technical advice to try to deal with this landfill issue? Because it's a problem on all the counties. And we can talk about all these great goals and objectives, but if we don't have concrete solutions, we're going to have difficulty maintaining jobs. We're going to have difficulty doing other things. And that might be, a similar type of harm on local working people. So I would urge the state to actually start stepping in and showing the leadership, or at least facilitating, trying to bring new solutions here, because I personally don't believe, based on the evidence that was presented in the Waimanalo Gulch case, that we can totally eliminate landfills. And we just have to try to be a little bit smarter and more aware about how we do it. But I do think that that decision was correct, because there is something, I believe, fundamentally wrong when certain communities end up with the dump and other communities don't. Thank you, Mr. Chair.
No problem, Commissioner Okuda. I'm sorry I didn't look that way. Does anybody else want to make a comment? Before anybody else makes a comment, I remember that case, and I remember that the first motion that you made was to deny the extension, and you and I were the only two votes, I think. It passed, but anyway.
Yeah, that's correct. That's correct. Your recollection is correct. It was denied the permit totally.
Do we have any other questions you want to ask?
Yes, Chair.
Mr. Kama, Kea,
Hey, you got it. First try. Right on. Mahalo. Daniel, mahalo for the great presentation. I just have one simple question, and this comes from the agricultural perspective and point of view. To the best of your knowledge, to the research and studies done, what is the best accepted practice to sequester carbon?
So the Office of Planning and Sustainable Development has attached to it the Greenhouse Gas Sequestration Task Force. It's another unfunded and lack of staffing board and commission in the state of Hawaii. However, what I want to highlight about that is it's one of the two climate boards and commissions in the state of Hawaii. So we have the Mitigation and Adaptation Commission, as well as the Greenhouse Gas Sequestration Task Force. So the Office of Planning and Sustainable Development, myself, the director, we've actually been working with that for the last 5 years, this task force. It is coming out with a preliminary report at the end of this year to the state of Hawaii about how we can best sequester. And of course, that task force has to come out with future reports every year following. In terms of increasing sequestration. In terms of the best, there is data, and there are entities that have actually conflicting data. How I want to answer your question is we just need to do it. So the best way to do it in agriculture, we can see that through our plant management, where our plants, our grasses, we can start sequestering more. We can see that through our ranching, right? And through just sustainable ranching management practices that the Hawaii Cattlemen's Council has actually testified that they are already conducting. We can see it through our forestry management as well. So these are the leading ways in our natural and working lands that we can start seeing more integrated sequestration opportunities.
Okay, mahalo for answering that question. Let me follow up with this question.
Sure.
For every new home built, exactly how much trees need to be planted to sequester and attain the state's goal of a carbon neutral society?
To the best of my knowledge, I do not have an answer to that question.
For the record, they don't know. Nah. Mahalo.
Okay, any other questions? I have a few. I have just a couple. You mentioned status 1, 2, and 3. Is it about different?
Scope 1, 2, and 3.
Scope 1,
emissions.
2, and 3.
Yeah.
For example, we have rock quarries on Maui, and we have a rock quarry going on. If we, one of the things is that we have the rock quarry serves the area, and it requires this transportation. If we were to buy those rocks and we have to ship them over, is that the type of choices that we must make in the future, whether or not to locally produce and these things versus shipping them in, which would add to the carbon footprint?
So in climate mitigation and carbon footprinting, you need to identify the source, and that is the scope 1, 2, and 3. Now that is a whole nother presentation, which I can provide to you at a later date if you'd like. There are no mandates on our state right now to this day on scopes 1, 2, and 3 emissions. Right now, we're just generally reducing emissions, right? I could see possibly as a sustainability professional where that become something later, where we, our policymakers start being more mindful of scopes 1, 2, and 3. But to answer your question, scope 1 is your direct, right? Versus the coming in is the scope 3. And when we start having these greenhouse gas emission conversations, Hawaii has a very large scope 3 emission, right? All of the imports. And right now, we need to figure out whether we're measuring those correctly and measuring them consistently.
And in the past, there was a big controversy on Maui about sand mining. And now, because the sand mining was transporting to Oahu or going off island. So my question would be, is that now Oahu may not be avail themselves of close by sand, which from Maui, and has to go out further. Would that kind of balancing test be applied in that kind of situation to determine whether or not we should meet carbon emission standards?
That's a really good question. And I think again, when we get farther out, that might become more prevalent as a question. What I think now, when we do greenhouse gas emissions, we need to understand that our sources right now, our electrical sources are fossil fuel based, are coal based, right? That is the lowest hanging fruit right now, right? Our transportation is 1% of our transportation statewide is only clean or zero emission vehicles, 1%, right? So when we think about emissions, it's our energy sector, it's our transportation, right? So when we start looking into materials or even our agricultural areas, right? I think that those are important, but we really need to focus. Okay. And it says so in our greenhouse gas emissions report, we need to focus on our energy sector and our transportation.
And I understand that, but from the Land Use Commission standpoint, I'm looking at situations where we may have to make some trade-offs because we don't affect fossil fuels much. We don't do that kind, do like, that's not our Kuleana or our Kuleana. So ours would be, how does the carbon preserving the, or getting the best carbon outcome versus balancing it off with the various tests that we must do with regarding the environment and different aspects of that. I'm just trying to put it all together in my mind because the carbon issue is our life, or is our life. But the question is, how do you place it within the scheme of making a decision on a land use matter that has all these other.
Sure, gosh, let me see if I think I can help Danielle out a little bit here. Okay, so with regards to special permits and DBAs, we have specific criteria that we have to take into account. And one of the points that I was trying to make at the beginning was that because we require sustainability information to be provided in these permits now, and because we're required to take the state plan and the various subsets of that into account, it's not unreasonable for a commissioner to ask a petitioner, for instance, let's say it's a rock quarry, how much, I mean, have you done a carbon analysis on how much emissions are involved with shipping sand over as opposed to mining it locally, and making that a part of your decision. If, for instance, the testimony was that it's, for whatever reason, I have no clue, that shipping the sand over was actually had a smaller carbon footprint than mining it here, then it's reasonable for the commission to make that a part of its decision. But once again, that evidence needs to be on the record. And a lot of times petitioners aren't prepared to answer that question.
And no, the only reason about the sand is that I live on a sand dune.
Well, we're going to mine under your house.
And the problem with the sand dunes is that it has significant historical sites.
Well, there are other issues.
And so, and so I'm just trying to figure out in my mind how we're gonna balance this out versus, because there's good things that we can produce here that will reduce our carbon footprint, our state's carbon footprint.
Well,
but then it affects other parts of the environment as well as the cultural aspects of it. And so I just look at that as a
well, it's actually an interesting question, because if there are cultural elements involved with sand mining, that's a public trust doctrine issue. But then again, it could be argued that, you know, carbon footprints are a part of, you know, impact the environment, and that could be a public trust doctrine issue as well. So I'm just glad I'm executive officer and I'm not a commissioner.
Well, I'm just glad I only have 2 more years. I'll be involved in it. But anyway, I'm just raising that as some issues that I thought would be interesting to raise. Does anybody have any other questions that they want to?
I have a couple of comments.
Okay. Sure. I recognize Dan or Nicker if there is for any final comments.
A couple of comments that I want to make. One of them is that Dan, we have the Land Use Commission staff year in, year out for 5 years now has done the best we could to support Danielle's efforts at the legislature for increased staffing. I have made it very clear to the legislators that Danielle not having staffing is hampering our efforts. And so I just want everybody to know that we're very much in support of what Danielle's doing and doing everything we can to try and get her the staff so that she has the ability to do some of these things that she's talking about. The second comment that I want to make is that, you know, there are some aspects of development proposals that we look at and that we should be concerned about that aren't as readily apparent as impacts with regard to sustainability and climate change. And none of the commissioners who are currently sitting on the commissioners, except for Nancy, I believe, were trained in or went to the conferences by the Blue Zones Project on walkable and sustainable projects. And the focus of those conferences was on livability, creating communities that are livable. But there's also an environmental side of that. If you create walkable communities, and we require walkable communities to be created, then you have two immediate impacts. One of them is on traffic, because now you have fewer trips, but those fewer trips result in fewer carbon emissions, which is also a sustainability goal. So that's one of the other things that we urge the commissioners to look at, is the walkability of the projects that are being developed. And hopefully we'll be able to get back to the Blue Zones group has not done one of those tours since before the pandemic, but hopefully we'll be able to get back to doing some of those so that the commissioners can understand what's happening. Commissioner Atta, were you privy to any of those when you were planning director to the Blue Zones tours? Yeah, quite good. Anyway, thank you, Danielle. Thank you very much, as always, and we appreciate it, and we will continue to do what we can for you.
If I may,
Yeah.
I wanted to just thank the commission again. You all took a vote earlier this year to support my budget request, OPSD's budget request. We did request for staff. It was in the governor's executive budget, along with operating expenses to help us work. Actually, one of our next steps ideally would be to create a climate adaptation plan for the state, but of course, funding provided. We did have that included in the governor's executive budget, our staffing and our current our operating expenses. It did pass the House of Representatives. In fact, the House of Representatives added to that and gave us just equipment, everything else to just help improve and modernize the OPSD. I want to report to you all with my mahalo that it was unfortunately not concurred in the state Senate. The State Ways and Means Committee actually deleted the state sustainability budget. We are, and my goal is to work with the State Senate Ways and Means Committee in the coming 2023 fiscal year in the biennium. It was a very sad moment for OPSD. Since we are transforming and modernizing and looking into climate and sustainability, which is quite exciting. But that doesn't stop us. We will continue what we do. And I just want to mahalo all of you for that support. So thank you for that vote. It was helpful. We actually testified to that and said the Land Use Commission supports this. Come on, but c'est la vie. And so we will move on to fight another day. Mahalo.
Well, you're welcome. Thank you, Daniel, and the Office of Planning and Sustainability and Development. And I would be remiss not to say that we also even thank Brian Yee. So, okay, in this matter, I know what you want. We're going to have to take a hard or finish this off by 3:15 today, and what we have a few administrative stuff to do, but because I'm acting chair, I get to declare a break for 5 minutes.
Okay. Okay.
After Dan has his say.
No, I just wanted to, since we were on the subject, very briefly say that with regard to legislative matters, generally staff looks at potential bills for the upcoming sessions and budget issues. And in some cases, drafts legislation that we think would help make the commission's job easier. From a policy standpoint, if this commission feels that we should have a meeting to address what it feels would be appropriate for some to draft bills, for staff to draft bills for submission to the legislature, we can put that on an agenda at a later date. So just so you're aware of that we appreciate input from the commissioners, or we can have one-on-one conversations with, you can have one-on-one conversations with staff with regard to some of your ideas.
You might want to wait until after.
Well, unfortunately,
gonna
I
be
just
there.
got an email today saying that it's time to start putting together our legislative packet, so. Yeah.
So anyway, we're gonna take a break for 5 minutes only and come back here at 10 to 3 and finish up with what do we have to finish up on?
We just have, the only remaining items on, that we need to cover are just some administrative matters that Riley will be giving us a presentation on, and then closing, and that's it.
Okay, and normally I would say, let's go ahead, but because I'm acting chair, I get to say that we have a break.
You're the boss.
Calling it back into order, Mr. Ordinaker.
And the next item on, you get Kawika's name right, I've known you 8 years now, right?
Why break a tradition?
Yeah, I'm used to it. Okay, now we'd like to just cover some administrative matters. And Riley, who was for years the one in charge of all the administration and chief clerk, but has since moved on to more difficult things that are things that are more difficult for him. Let me put it that way. He'll give you he's going to give you a little bit of an explanation on some of the administrative things that you need to keep in mind.
This is the toilet paper portion of the meeting. Often overlooked, but very, very necessary. And if you don't pay attention to it, it gets very messy afterwards.
Oh. Riley's a walking HR problem, in case anybody doesn't know that.
Oh, okay. Well, first of all, mahalo to the veteran commissioners. They're made my life as a chief clerk very, very simple. I cannot tell you what kind of troopers they've been, because through the thick and thin, they've been able to make regular attendance to all the meetings punctually. And it's made us able to conduct a lot of business efficiently. And sorry, but they set such a high bar for all the new guys. That's the expectation. So if you cannot make it, we try and project far out in advance what our meeting schedule is going to be, so that you know and can mark your calendar, reserve your days. But sometimes when no can, like the accommodation we had to make with a meeting on a Tuesday yesterday. And that's when we have to scramble. So just to kind of give you an idea of how much money is involved with these meetings, it can range anywhere from $3,000 to $6,000 a meeting when you factor into all the LUC staff time, your valuable time as commissioners volunteering. And if we have a presentation by, say, a petitioner, they appear, these high-priced attorneys, but they have expert witnesses on hand. And if it all caves in at the last minute, it's a lot of money down the drain. So we try and avoid that at all costs. So fortunately, my chief clerk position has been replaced with two much prettier women and much more efficient and smarter than I. Again,
HR problem.
Just calling the truth. But they are much better at doing my job than I was. And they'll seek you out, let you know when the meetings are in advance, get a head count so that we can be sure we have quorum to do business. Sometimes, when things happen, but we try and book facilities far, far in advance so that we secure some place to meet. In the past, when we attended in person, it wasn't a problem because we didn't have to worry about Wi-Fi availability. Now we're so high tech. We depend on cameras. We depend on making sure everybody has an iPad so you can tune into the meeting. Now we have the website. We have a commissioner's checkpoint for you to stay in communication and contact with us, email. And they're so good at following up with you on your attendance and all that. it should be very smooth sailing going forward as long as we have our calendars all set. And sometimes even that at the very last minute will blow up in our face, but we can reduce it as much as possible by being very attentive to our schedule. I just want to make sure that we do travel a lot, and it's important for you to know the benefits of our corporate Hawaiian Airlines corporate account, because a lot of times you're looking at the watch and you're figuring, oh, what about my check-in for my flight? If I want to leave earlier, how do I do that? Well, because of the corporate account, leaving earlier is not a problem, right? You just, we do the jailbreak to the airport. You check in with Hawaiian Airlines staff and let them know, my meeting finished early. I want to try and get out on the next available flight to wherever your respective island is. They put you on the standby list, and then you're set to be called for that flight. If it's delayed, then we'll try and make an accommodation. But oftentimes we find out a little bit too late. So same thing, if you end up in a delay situation, we'll try and contact the airline, let them know. But if you get separated from us, you just have to just fess up to the agent and just say, I missed my flight, corporate member. I want to try and get back to my home island standby, and they'll try and accommodate you. But you do have a little better ranking because you're a corporate member. And we'll be traveling a lot more now that COVID is kind of in the back rear view window. We did ask you all for some very sensitive information to secure your credit card, all that. The way it works with your credit card, there's stuff that our P card, our credit card, departmental credit card can pay for, but they cannot cover stuff like hotel rooms. So if we're going to travel and it requires an overnight stay, we're going to have to use your credit card to secure that hotel room. So that's the bad part about being a commissioner. You guys working for Aloha, but you might end up having to front some money as far as your hotel bills go. We'll try and reduce that impact to you as much as possible, but that kind of falls into the second part about making sure you get your receipts all in order and submit them as timely as possible. And not only your receipts, your boarding passes as well. Okay, so all that paperwork involved with your travel, turn it into any one of the LUC staff so we can collect it and get it to the admin services office so that we can start processing your reimbursements. And they're on this cycle with the payroll. So the faster you get it to us, the faster you get your reimbursements. So it's not only a one-way street of giving to, donating time and money to the state bank, but there's some payback as well. You get to travel a lot. You probably easily make Fulani gold. But there's some educational benefits as well. We have conferences periodically that certain commissioners will be able to get to it if the schedule allow for it, either locally or on the mainland. And as they come up, then we'll be contacting you to see if it fits into your schedule and whoever's available and can make it. Some of the veteran commissioners can tell you it's not all work. Actually, you're not supposed to have fun, but you do have fun when we travel.
No fun.
No fun. Again, there's also the site visits. Site visits were mentioned. We haven't been doing them because of COVID, but many times we'll go to petition area, and depending on which island it is, sometimes you get to see sites of pieces of Hawaii that you've not been able to see before. Because for myself, I was able to go onto Parker Ranch and the Robinson Ranch on Kauai and on the Big Island for the first time. And otherwise it would have been kapu, no entry. I couldn't have seen the beautiful landscape and get to hear it from the families or the property managers themselves. You hear the story of what's involved with the landscape, and it's very rewarding for me. That's what makes working at the Land Use Commission a lot of fun for myself. It's a learning experience. Even when you sit in and you hear public testimony or you hear the expert witnesses during a presentation on a petition, there's always, for me, there's information that's been popping up that I never knew before until I heard it firsthand. And sometimes, you can suffer from overload of public response, like when we had the petition for IAL on Oahu. I don't think anyone else in the office got to talk to the 300 people I got to talk to that were all upset with being included or not notified that the land was part of the list of properties to be declared important ag land. But you do get to see members of the community step up and step forward to be heard. And, it kind of takes, you give them a lot of credibility because they care, and sorry. Chair Scheuer was really good at that. He would really empathize with the public. And they saw that, he wasn't faking it. It was for real. So I think, again, high bar set. And that's kind of like the expectation level that, the public is viewing you in. And now that we have Zoom, there's a TV audience out there that's also viewing you. So if you're not prepared for a meeting, show. Like, when they go and interview somebody off the street, and if they don't know anything, they don't know anything. So you got to really be prepared for our meetings. So we try and prepare you with our staff reports as much as possible so that you're ready, to deliberate when you come in. I think that's pretty much what I needed to let you know, but main thing is you continue to check in with our commissioner's checkpoint. We worked hard to make sure that a lot of that information is current and very important to you. Other things for you to know, you might have missed it a little bit earlier. There's that Ethics Commission, yearly they'll let you know that you need to file a financial disclosure. Every 4 years, you have to take an ethics course. And even LUC staff will be taking a course later this year. There's also Native Hawaiian law course that's offered at the university. For the attorneys in the audience, they've been able to pick up their continuing education credits that way. But it's really good information to know. Again, you get to learn the history of Hawaii. Some of it is, I know some of you were asking questions or using the chat because I sat in on that, and I'm pretty sure that you benefited from that. I saw your comments. Other things that you need, like parking permits, very simple stuff, but if we have a meeting and if it's at the State Office Tower or if you need to make a visit to the Capitol, we have parking permits available. I know Mel got a couple of current ones. I did give you outdated ones. I apologize. I gave Kuishi outdated ones too, so don't use them. You get tickets.
I don't available for the airport too.
For the airport, you have parking permits that we've acquired for you from the Department of Transportation. So pretty sure Ariana got them out to you. If you haven't, we have your parking permits for the new commissioners. There's information that you need to write on the back side of the ticket that you receive that will involve your license plate number, your permit number, the department you work for, all that. It's spelled out in the fine print in the back of the parking permit. But at the respective airports that you go to, it should get you in and out of the parking lot without you having to pay. To think about ecology, Martina's made sure for me to ask, if you don't need printed copies, let her know. If you can
If you want printed.
if you want printed copies, to let her know. Otherwise, we'll assume that you're okay with the checkpoint electronic digital version. See, and finally, I know we're going to be going to HCPO next month, the Hawaii Congress of Planning Officials. And the hotel is already booked, the host hotel in Poipu. So the alternate hotel is the Royal Sonesta in Lehui. So some of the LUC staff is going to have to stay at Royal Sonesta too. So we'll figure out the logistics of transportation and all. But if you could finalize and confirm your wish to attend with Ariana, that would really be appreciated, because trying to make sure that you have, if room runs out at the alternate hotel, then I don't know where we're gonna come pick you up at the top 10 out of the beach somewhere.
Yeah. He's got a good liquor cabinet too, so.
That's pretty much it, yeah. I think so.
Okay. That last slide about who's willing to be a driver, I thought that was.
Oh, yeah,
directed at me.
right. Yeah, okay. Yeah, I didn't look, but see, I have a reason, poor eyesight, so. Yeah, and going along with the logistics, just by show of hands, who doesn't want to drive? In case you get into a pinch and we need drivers from a commissioner to be a driver, who doesn't want to drive? Raise your hand so we won't. Otherwise, okay.
Does not want it.
I'm old, that's why.
Yeah, me too.
I wasn't gonna stay overnight.
Oh, no.
It's just for any meeting.
Any meeting.
Who would not want to be a
Yeah.
driver, because sometimes we're short drivers.
Yeah.
Okay.
I'm always
willing to drive.
Okay.
Okay. With that, I think that wraps it up.
Okay. Okay. Is there anything more?
No, just some closing comments.
Okay, before we do that, I want to recognize Ariana or Mom, if she has any more comments to add to Riley's. You have anything? You have anything to add, Mom? Seeing that she doesn't have any more. Ben? You wanna-
That concludes our training session. I know there are more questions. If you have them, please ask staff. But, this land use commission can be a lot of fun. All we ask is that you show up and that you make good decisions. But as you may have noticed, some of the newer commissioners may have noticed, we spend a lot of time together and we develop a lot of camaraderie. We have good commissioners. All of us are great people, and we enjoy each other and we enjoy what we do. So I have to say, I'm blessed with probably the best staff of any organization in the state. Every one of them is just incredible. I really have to thank Scott and Riley, and especially Martina and Ariana, for helping us put this together and doing a lot of great work for us and very efficiently. But we're here for you, and we're here to serve you, and whatever you need us to do, just let us know.
Okay.
Thank you all.
Is there anybody else want to make a comment before we adjourn? I have a few things that I have to do, as our next meeting will be at a remote location and we intend to work through the lunch. I would like to request the LUC staff to arrange for lunch to be provided to the commissioners in order to facilitate the meeting. That's one of the things I have to do. The second is I want to thank Dan and the staff. I agree that they are the best staff that I've known. And I think that I can say that for sure because I have been here for about a couple of years now, and I can attest to their competency and quality. And I want to thank them for putting on this great training session. I want to acknowledge that Riley does have bad eyesight because he picked me up at the airport today and you know, and I had to go, I had to get out of the car quickly. So, and this concludes day 2 of the Land Use Commission training. Next time that I am chairman, you don't have to call me chairman. I'd be glad to go by the honorific of sir. If there's no further business, I declare this meeting adjourned.